I am the plaintiff. Confirming judgment. Suit was for declaration that the gift deed executed in favor of the defendant that has been obtained by practicing fraud, undue influence, coercion, threat, and other consequential things. Yes. And subsequently, another prayer is also made in the plaint that subsequently the executant herself came forward and executed another deed for revocation of the who had executed a gift deed? My lord, plaintiff's mother. Plaintiff's mother had executed a gift deed in favor of the defendant. Defendant number one. Defendant number one. What is the relation between you and the defendant? Yes. There is only one defendant. My lord, only independent. So I'm sole dependent. Sole dependent. What is the relationship between you and the defendant? My lord, I am son of the plaintiff, a son of the executor. I don't get it. Your mother had executed the gift deed. My mother has executed the gift deed in favor of the defendant. How are you related to the defendant, or he is a stranger? No. He is defendant is the brother of plaintiff. Defendant is the brother of plaintiff. Plaintiff is the son. Sorry. साधारण कथा को बुले कि एमिति आपण कहउछन मु बुझियो के सॉरी ये भाई के भीतर कथा जण पुओ ना रे गिफ्ट डीड करा गला नहीं सॉरी मु टिके कहि परलिनी डिफेंडेंट इज द ब्रदर ऑफ द एक्जिक्यूटेंट executant is my mother. He is the maternal uncle of the plaintiff. Yes. You know, Mamu. So Mamu Nare say Cordele gift deed. That you challenged as null and void. Why? On what ground? Was it a registered deed? It's a registered deed. Yes. Then subsequent to the execution of that deed, the executant came forward and revoked that gift deed by executing another gift of cancellation before the concerned register. Even though, in fact, my lord, this is not maintainable because once the deed has been executed, that cannot be cancelled by the same sub-register. It should have been decided by the competent by the civil court. To that respect, my lord, I do not have any dispute. I do not say, my lord, this. My lord, so but what is your case? My lord, my case is that my father died in the year 1990. There was nobody to look after our family. By that time, I was also so young. Taking advantage of such situation, my mother requested my uncle to take care of our property, to look after our property on our behalf, or to manage the property, because she was a helpless lady by then. She was the karta of the family, but she was helpless. And the property is a joint family property, ancestral property, or self-acquired? No, it's ancestral property of my father. All father. Subsequently, it was inherited to my mother and to me. My mother, under impression that a power of attorney is going to be executed in favor of my uncle, she executed a power of attorney, but in the shape of a gift deed that was not in my knowledge, to manage the affairs of my property, of my family, and to look after it. Under that impression, my mother executed. Is your mother a Pardhan machine? No, not in fact. Not in fact, because I cannot develop by this process, because she has put her signature in English. That is the very crux of the matter to be decided here. My lord, after execution of such power of attorney, so far as my case is concerned, the defendant, some days, he took care of my property. He was one of our family member, like managing the property. But after 10 or 15 years thereafter, we were under impression that this deed has been executed. It means, I mean to say, power of attorney has been executed. But subsequently, in the year 2010, the defendant, he played hide and seek role. He directed the tenants where we have lets of property in favor of tenant to let out the property. So what he did, the defendant, he directed the tenant to pay the rent in favor of this defendant. So we objected. Why should? Because we are the owner of the property. Yes, of course, we have given some power to you to manage the property, not to hold the property absolutely in your favor. So by that time, he disclosed that you do not have any power over this property, because once a deed of gift has been executed in my favor, I am the absolute owner of the property. So right now you are stopped to claim. Right. That was the cause of action for coming to the suit, for filing the suit. Yes. Yes. No, my lord. That was held in the year 2008. So when my mother, my lord, after getting inquiry from different sources that a deed of gift has been executed after the disclosure of defendant, my mother applied for the certified copy of the documents
First of all, I invited him to produce this original gift deed, my mother, but he did not produce. That is why my mother was, my lord, she was enforced to apply for certified copy, and thereafter she came to know that a gift deed has been executed. And subsequently, my mother, what she did, she immediately cancelled the same before the concerned register, showing her intention that this gift deed has not been executed, but it was in the shape of a power of attorney. That was the intention of my mother by then. Thereafter, my mother died. So, cause of action arises on, so that is why I was enforced to file the suit. Otherwise, I won't have. My mother had cleared her intention by revoking such gift deed by way of cancelling the same before the concerned register. Had she not been, then matter would have been different. I would have come forward to say that this would have been a collusive suit. But my mother had showed intention before the concerned register, even though this is not accepted, in fact, as per the section 17 of the Registration Act. Thereafter, in this suit, I said that this deed has been executed fraudulently by impressing that this deed of gift is going to be executed, not a
power of attorney is being to.
Yes. So, my lord, the Law and Trial Court has framed three issues. Number of issues, but three issues are important. My lord may kindly come to the part of issue. That is at page 19 of the Trial Court's judgment.
Issue number 3 is important.
Yes, issue number, sorry. Issue number 3 is important. Whether the gift deed bearing number so and so, obtained by practicing fraud part is to be decided. And this, the second issue is consequential. That subsequently the deed of gift of revocation, that is to be held as good.
So he who alleges fraud must prove it.
Yes.
How have you proved it?
Yes. My lord, your lordship may kindly come to page 23. Well, this issue has been decided. I only point out the crux of the case.
Yes.
Here, the Law and Trial Court hold that you also one of the signatory to the gift deed, my lord, this plaintiff, and your mother was also signatory. Your mother had put her signature in English. You also put her signature in English. My contention before the Law and Trial Court is that this was my pleading before the Law and Trial Court, that even though I had signed in English, but I am unable to understand the language of English, the contents, sentence that are not understandable to me, because only my capability is to sign the document by way of English. Only I can, to that respect, I can read. My mother and myself also. But this deed has not been read over, explained to me. And the scribe who has written the document, he has also not been examined. And the witnesses, my lord, who have been witness to this gift deed also, they have not been examined.
You should have examined them. You should have called them to the witness box.
My lord,
you are the person who's alleging fraud. The entire heavy burden is on you. The onus is on you. You fail to discharge that onus. What is wrong in the finding?
My lord, in fact, when I am subject to your lordship's consideration, my lord, when I am disputing that this gift deed has been executed in favor of so and so person, my lord, by a lady, my lord, even though she is a Pardanation lady or anybody.
No, she is not a Pardanation. Yeah, that is why I asked you.
I am coming to this point, my lord. Even though Pardanation or any lady also, if a deed has been executed in favor of a person, he or she must prove that section 68 of evidence has been complied with.
That is not the law. That is not the law. Well, only where there is a doubt as regards the proper execution by a lady who is old, infirm, Pardanasheen. My lord, there only that a Privy Council decision, my lord, by Supreme Court in many cases.
My lord, there should be legal presumption to that effect. Then when the lady herself has come forward to say that this deed has not been executed, that is why he revoked such deed by way of cancellation of
conduct, you see, that is an invalid document. Revocation. Revocation is invalid. There is no concept of revocation in law.
No,
she should have filed a suit. Like you have done.
Sir, ମୁଁ ଯାଉନି କାହିଁକି ନା ସେଟା ମୋ ବିରୁଦ୍ଧରେ ଯାଉଛି
ସବୁ ଯାଉଛି
but her intention is very clear from the document itself that she did not want to execute any gift deed in favor of so and so person. Her intention must be
finding of fact
ମାଇଲର ଅଛି କିନ୍ତୁ ହଜୁର ଟିକେ ଦେଖିବେ ଦ ଗିଫ୍ଟ ଡିଡ୍ ଇଟସେଲ୍ଫ ଇଜ ଭଏଡ୍ ଡିଡ୍। ମୁଁ ହଜୁରଙ୍କ ପାଖକୁ ଟିକେ ଖାଲି ପଏଣ୍ଟ ଅଫ ଲରେ ଆଜ୍ଞା ମୋ ମେରିଟରେ ଆଇ ଡୋଣ୍ଟ ହାଭ୍ ଏ କେସ୍ because it's a conferring judgment concurrent findings of the law and trial both the courts below, but I have a point on question of law and that could be raised at any point of time, my lord. That has been ignored by the law and courts below.
What? That ancestral property? So
No, not at all, man.
then what?
Once a gift deed has been executed as per section 122 123 of the Transfer of Property Act, my lord, may kindly see khali gotte point hote
Please, you are free to argue. Don't think that the court has closed its mind. Court may raise a question, doesn't mean that this is the final opinion.
my lord, I am challenging the very execution of the gift deed itself. It is a void deed. My lord, the conditions of execution of gift, section 123, transfer how to be effected. For the purpose of making a gift of immovable property, the transfer must be effected by a registered instrument. Here it has been done, signed by or on behalf of the donor. It has been complied with and attested by at least two witnesses. One witness has been here as a witness, one witness only. No,
Samatra, you are forgetting one thing, very important thing. That is also a point of law.
Right.
Waiver, acquiescence, and estoppel, you were yourself a signatory to the deed according to your own admission.
my lord,
So are you not bound by the principles of waiver, acquiescence, and
then I will come to the evidence act, my lord, subject to your lordship's permission.
Please.
My lord, yeah, for the evidence act. For the purpose of making a gift of immovable property, the transfer may be effected either by registered instrument, signed or aforesaid, or by delivery. It is not under dispute. My lord may then kindly come to evidence act.
Now, before that, what was the finding of the trial court?
My lord, finding of the trial court is that once you have signed your document in English, then you must be in a position to understand the contents and language of the English.
When was the deed executed?
It was executed in the year 1992.
92. And when was the suit filed?
Suit is filed in the year 2011, perhaps. Well, after limitation period.
No, what is the year? I want to know.
2011, my lord.
2010.
2010.
So 92, the deed was executed.
Executed.
So 92,
Limitation.
so many 18 years. 18 years. You were aged about, you have mentioned
43. But then
18 को लेके तय लगा।
23. 23.
So 23 years वाला लोग कहले जे मुझे पहले नहीं साइन कर
My
देगी।
lord,
English में sign
practically it is not possible. Even though 23, he must be in a position to understand the contents of the deed and the.
You should have challenged it at that point of
Like,
time.
sir,
Anyway,
ମୁଁ କଜ ପର୍ସେଣ୍ଟ ଅଫ୍ ସେଜକୁ ଆଣୁଛି 2008 ପରେ ଆଣୁଛି ମୁଁ ସେଜକୁ ଟିକେ my lord may kindly see evidence sir.
yes. 68.
68. That your lordship
Two attesting witnesses.
attesting witness, then another point your lordship raised that once you are a signatory you cannot challenge it.
No, I'm not saying that you cannot challenge. Under this circumstance,
This sir.
here, the from the on the factual scenario, I'm saying that you cannot challenge it in this particular case.
Then my lord proviso may
Yes, please.
Section 68. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. Here it has not been done. I will come to that point also. If there be an attesting witness alive and subject to the process of the court and capable of giving evidence, then proviso, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will, which has been registered in accordance with the provisions of Indian Registration Act, unless its execution by the person by whom it purports to have been executed is specifically denied. Well, here, if I would not have denied the specific execution of this gift deed, then calling for attesting witness to the doc is not necessary. But here, myself had cleared my intention by revoking the earlier gift deed, saying that this deed has been executed behind my back. Then, my lord,
You came to the court on the ground of fraud, raising fraud. So it is not, you are not saying that the deed was not validly executed in terms of section 68 of the Evidence Act. You are saying simply you are claiming that it is a fraud.
fraud. Now, execution
Because he claimed that he was executing a power of attorney,
okay.
but actually it was a gift deed.
Execution is good, correct, but it has been obtained by fraud. That your lords. Well,
So whether this is any further available for argument.
here, well, execution is specifically denied means I executed a deed of power of attorney, not a gift deed.
So basically it boils down to fraud. Fraud. It boils down to fraud.
So here, plaintiff can raise this question. Of course, plaintiff is not, the executant is not alive. Had she been alive, matter would have been different. So that is why I am saying,
So what
had
was
she
the
been
finding?
alive also.
What was the finding?
My lord, finding is that there is no finding at all to that respect. Only says that once you have signed the document in English.
No, he framed an issue with regard to fraud. Why should he go into the finding of 68, under 68? So, he has specifically framed an issue relating to fraud, basing on the pleadings.
Pleadings.
So, that what does he hold?
My lord, the question of fraud, that should be specifically pleaded in the plaint. It has been, my lord, the finding is that no pleading in respect to fraud is specifically mentioned in the plaint itself, even though this is not correct. My lord may kindly see, I have the plaint with me. Here I have specifically said, what more I could have said.
Let us read it. Let us read that portion of the trial court's order. It is issue number 3.
Issue number 3.
Yes.
Here khali gote kotha koi dauchi. On the other hand, defendant has examined only one witness on his behalf. Attesting witness ke asina. My lord, relevant portion is at page 24.
Yes.
My lord, it starts from the word there after 1, 2, 3, 4, 5 lines from the top. There is no doubt has been created regarding the lack of in English knowledge about the contents of Exhibit L. Exhibit L means that gift deed, original gift deed, on the part of plaintiff and his adoptive mother is not found sufficient in view of the signatures put by them on it in English. It is also found that one of the attesting witness to the said document was the father of said Rajkusuma. My lord, Rajkusuma houchanti je executant ebong defendant tankor bapa. Only one witness was, my lord, there in the gift deed. That gift deed from the very inception is bad, my lord. This is void document. So putting signature in English and later on claiming that they are unaware of the contents of the document is not acceptable. When the first line of the said document mentions as name and addresses of the donors, there is no mentioning of any power of attorney as claimed by the plaintiff. Thereof, much reliance cannot be placed on the version of the plaintiff that he was unaware of the nature of the document created in the year. My lord, here the circumstances should have been also taken into consideration. A person, my lord, I am putting question to myself, why should he will be executed a gift deed unless any law of affection on any other circumstantial things are available? Well, when my son is there is no materials on record to show that this gift deed should have been executed in favor of so and so person.
You have not taken the stand that the property being ancestral, the mother could not have also executed a gift deed in favor of a stranger.
By this process, perhaps, my lord, I could not have developed my case because I was also one of the signatory to the. And second important thing is, I retained the possession till yet. That is also have been considered by the law and trial court. And there was a condition in the gift deed that till my death, I will enjoy the property, and after my death, you will enjoy the property. That means in the shape of a will.
Okay, so what was the final finding? That he did not believe so far as the fraud is concerned.
This gift deed was accepted, in fact, saying that you have executed the deed. So, and knowing the contents of the same. So, right now you cannot dispute it.
So, what happened in the first appellate court?
That judgment was confirmed in the same way, my lord, and only on the same way, these questions of law are not being taken into consideration, whether this gift deed is a void deed or it should have been proved by the defendant, because the defendant himself has filed a counterclaim. It's a suit like. He should have also proved this document saying that this has been executed properly. Had he not been filed any counterclaim, matter would have been different. And the burden of proof completely exclusively lies to me to prove that document itself is a good document.
So you're basically your claim is on the on fraud.
Fraud.
So if you are unable to prove that, which 2 courts below have found, why will this court now interfere? Unless you say that the finding is wrong, perverse.
May I say one thing, my lord? I am right now hampering this. The deed itself is a void deed. My lord, not necessary to declare it a void. Because the deed itself is a void, it has not been properly executed by complying the provisions of section 68 or the transfer of property.
You are not, it is not open to you to make that argument. You are yourself a signatory to the deed.
My lord, that aspect, my lord, I would like to say, my lord, I do not dispute that I have made signature. But this signature, when I put this signature, there must be two witnesses looking to my signature.
Let us see the first appellate court's order.
My lord.
Now come to page 64. When input judgment decree this
My lord, of course, it's a confirming judgment. Only this point of law is in my favor. Otherwise, so far as merits is concerned, I may not go because in second appeal, substantial question of law is to be taken into consideration only, not the fact. My lord, who district judge?
Yes, 64.
It starts from the page 49, and the
Come to page 66.
yes.
Nil.
66. My lord, Lord and district judge
I have gone.
categorically held that the plea of fraud should have been specifically mentioned in the plaint itself with clear and definite fault. And the general allegation is insufficient to prove that fraud has been committed. But a number of decisions are being cited here. I am not disputing the question of law to this respect because Order 6 is there to bar. If you are going to plead, then is Order 6 Rule 4 perhaps, my lord. 6 Rule 4. Fraud must be specifically pleaded in the plaint. My lord, in this aspect, my lord, my case was not being considered, even if other factors are there. My lord, questions of law are there, my lord. Very execution of the gift deed is void. One attesting witness, two attesting witness at least should have been there. My lord, the document section 123 says, my lord, the document needs to be attested by two witnesses. Section 68 says, if the document is.
I've heard you. I've heard you. Not inclined.
My lord,
Dismissed. I'll pass an order.
I go to him.
I go to the no.
I go to the next week.
What more could you have argued? What more could you have argued, Mr. Samatra? You have made a very gallant attempt. You have made a gallant attempt. Yes, yes. You are a good lawyer. A good lawyer. I know you for more than 30 years now.
So far as my capability is concerned,
Your capability, I fully respect your capability, but in this particular case, I am not inclined.
हजूर सेदिन पछे डिसमिस करे गोटे सुजोग दिया
ना
नहीं हजूर
एते समय देई साला पर आबो बनी एते समय देई साला पर आबो
सेदिन हजूर को विश्राम देबे सेदिन तो
नहीं नहीं
हजूर टिके मते गोटे दिन आज्ञा मु ए नंबर 1 रे रहू आ गोटे पॉइंट काले काले किछि गोटे कोटी पारी
all right, heard in part, let's this matter tomorrow.
सर tomorrow
Oh,
हां
tomorrow. Yes, I can note to.
My lord, the petitioner is husband
Yes,
of the opposite party number 1.
yes,
Wife filed an application under section 125 of CRPC in the court of the Learned Judge, Family Court, Baripada.
yes.
The petitioner has made prayer to transfer that petition from the court of the Learned Judge, Family Court, Baripada to the Learned Judge, Family Court, Kendrapada, on the ground that the petitioner is a government employee. He is working as a RI in Kendrapada, and the wife, the husband has been taking care of his wife and children. At the instigation of my parents in-laws and in-laws, my wife has filed such case in the court of the Learned Judge, Family Court, Baripada. There is a possibility of amicable settlement, my lord, between the parties.
You settle. Open. 125 proceeding. You are a government employee. I can permit you to apply for appearing through virtual mode also, if necessary. Why should the case be transferred? 125 proceeding from Baripada, the lady will come to Kendrapada. Rather, you are a government employee. You can go whenever your physical attendance is necessary.
My lord, may I submit, my lord, that I have already taken averment in the body of my petition. Yes. That I have been maintaining my wife and my child.
That is to be decided in the 125 proceeding. if actually she has made some allegations against you, that why did she file that 125 proceeding? Claiming maintenance, obviously.
Claiming maintenance.
Obviously,
My lord.
it must be her case that you are not maintaining her. Now, your case is that you are maintaining
Not
her.
only
It's a
alleging,
question of evidence, Mr. Prusti.
my lord.
It's a question of evidence. How many?
My lord, let it notice me.
No, notice. The petitioner, husband is seeking transfer of, a proceeding in CP case number 267 of 2023 from the Court of Learned Judge, Family Court, Baripada, to the Court of Learned Judge, Family Court, Kendrapada.
My lord, CRP.
CRP actually.
CRP number.
Filed by his wife, opposite party number 1. So opposite party number 2 is his minor son. It is submitted that the petitioner is a government servant working as a revenue inspector. Further, he has been maintaining his wife and son regularly. In any case, it would be difficult on his part to travel from Kendrapada to Baripada on the date of posting of the case. He therefore seeks transfer on the ground of inconvenience. Having considered the submission as above, and on going through the petition, this court is of the view that, considering the economic status of both parties, it would be more inconvenient for the wife and the minor's child to travel from Baripada to Kendrapada than for the husband to travel from Kendrapada to Baripada. Under such circumstances, I am not inclined to grant the prayer for transfer of the proceeding. Stop. The transfer application is therefore dismissed. Stop. It shall, however, be open to the petitioner, husband, to seek permission of the court below, to appear through virtual mode, which shall be considered, having due regard to the fact that he is a government employee, required to work in the field. Stop. Further, unless absolutely necessary, the physical presence of the petitioner shall not be, of the parties shall not be insisted upon by the court below. Yes.
I cannot read.
Avatachi?
My lord, in this case, the wife has also filed a application under section 125 of CRPC in the court of the Learned Judge, Family Court, Keunjhar, my lord. And earlier, the wife had filed an application for transfer of civil proceeding relating to divorce case, dissolution of a marriage.
Who has filed the divorce?
Husband filed.
Husband has filed.
Husband filed.
Filed at Keunjhar?
At Kendrapada, my lord.
Kendrapada.
In the court of the Learned Judge, Family Court, Kendrapada.
Yes.
In that case, the wife had come before your lordship. On perusal of that petition, your lordship was pleased to put up that matter on 17/5/2024.
So this, let this come along with that.
My lord.
Let this matter on 17/5/2024, as it is submitted that connected
That is
matter being
TRPC number 49 of 2024
TRPC number 49 of 2024
to 24.
24 is posted to that date. Yes.
17/5/2024. My lord, further proceeding.
Yetire.
Ethere ଅଛି ଗୋଟେ.
In the meantime, if any application for adjournment is moved on behalf of the petitioner husband in the court below, the same shall be considered, having due regard to the date fixed for hearing of this case.
Item number 4.
May I please, Lordship? Your Lordship, on behalf of Siddharth Gautam Das, my lords, Your Lordship, here in this case, the petitioner is praying for his case from to transfer from JMFC Nimapada to JMFC Bhubaneswar, Your Lordship. Here, my lords, the petitioner is the offense committed is, Your Lordship, under 138 NI Act, my lords.
Yes.
My lords, on the date of posting of the case, the petitioner was threatened and was beaten by the opposite party, my lords. The allegation of a page.
You filed a FIR. Did you lodge an FIR?
Your Lordship, on page number 14, my lords. I have sent a mail to the SP, Your Lordship. On 31/1/2000, as it reads, my lords, on 31
Page number?
14, my lords, 14.
Page number 14 is a medical report.
No, Your Lordship.
वो मैटर हम खोल देंगे आइटम नंबर 4 तो हाँ ठीक है
That is in page number 6.
पेज नंबर
6 minute.
ओ पेज नंबर 6 को से पेज नंबर 14 को पर्सन Take notice. Issue notice to the opposite party number 2 by speed post, fixing a short returnable date. Requisites shall be filed by tomorrow.
My lords.
Place this matter on
20th May.
all right 20th May.
Your Lordship.
Item number 5.
May it please, Lordship. Lordship, petitioner is the wife of filed a transfer petition before the petition court. Transfer of the MAT case number 15 of 2020.
From Athagor to Cuttack, why?
Lordship, DB case is pending in at Cuttack. Lordship, petitioner is a chronic asthma patient, Lordship.
Yes.
Asthma patient, Lordship.
Everybody is an asthma patient.
Petitioner, wife, Lordship. And Lordship, annexed, sir.
Is a proceeding for divorce or DVM's case? Is a PWD Act.
My lord. DB case pending before the JMFC Cuttack at by the wife.
Hmm.
And husband was filed at Athagor, Lordship.
Athagor to Kono, divorce. So you want that to be transferred to Cuttack?
Well.
All right. Take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow. Place this matter on
Lordship, I have
13th May.
filed first.
Further proceedings in MAT case number 15 of 2020. No, in the meantime, if any application for adjournment is moved by the petitioner wife in the court below, the same shall be considered having due regard to the date fixed for hearing of this case.
Public.
Item number 6.
On behalf of Mr. Deep, 1 week time.
You want an adjournment? All right,
Sir.
list this matter 1 week after as prayed for.
Item number 7.
May I please? Your Lordship, Dhananjay Charan Dev case, sir. I have
Dhananjay De,
my lord. I have separate corrected copy, my lord.
correct कर दीजिए
My lord.
कौन सा देखिए कर दो all right दीटा का अच्छी connected
Yes,
matter
yes,
अच्छी
sir.
है
Right, sir.
Item number 8.
May it please, Your Lordship, my lord.
item 8
Lord, this is a matter, my lord. I will also make a small point that the advertisement unequivocally expressed, my lord, my scale of pay, and the opposite party is not disbursing the same amount. And only
have you filed the legible copies of the annexure 1?
I have filed, my lord.
What is this matter, please tell me?
This is a matter, my lord. While serving as assistant teacher, the petitioner, the opposite party floated advertisement under annexure 1, and in pursuance, I participated and was selected as BRCSE, and I was appointed with effect from my lord 16/3/98. I was appointed as BRCSE. Therefore, I was superannuated on 30th/6/2023. The scale of pay mentioned in the advertisement, as your lordships already have a glance over the matter, my lord. That is 1700 to 3200, my lord.
In the advertisement.
Advertisement. May annexure 1 page 13, my lord.
Advertisement तो देखा जाऊँ बोली मुझसे इतने कोई दिल where is the legible copy?
After the, sorry, my lord, another copy. My lord,
ନିର୍ଦ୍ଧାରିତ ଦରମା ହାର
Yes.
ବ୍ଲକ ସାଧନ କେନ୍ଦ୍ର ସଂଯୋଜକ 1700 ରୁ 3200.
27.
Yes. So,
They are not giving that.
no, so what happened? Let us see.
Then Miller annex to annex to 2 Miller, because they are not giving, therefore annex to 2
No,
page
no, Annex 2 is the
14. That is relating to
appointment order.
appointment order, that is relating to disbursement of the amount, the scale of payment.
Scale of pay, you will be taken later on. But what was the, they will be entitled to their own scale of pay plus DA, DA so and so.
My own scale of pay, Miller, that is as per advertisement, that is 700 to 32,000. They are not giving, and I have been supervised in the meantime. With the opposite,
Then what happened? Let us see.
they are not giving the opposite.
No, they're not. Happened. Did you make any claim?
Yes, yes. Miller,
Was your claim rejected?
Yes.
Let us see the impugned order.
Annex 5 Miller.
Annex 6 is the impugned order. Let us see.
Annex 6 Miller, my representation, 5.
Kindly place the Annex 6. The relevant
6
photo.
page 20 Miller. Plus 20 Miller.
Place it from paragraph 3 onwards. That the petitioner is Somnath Ram.
Yes, paragraph 3.
Yes.
Petitioner Somnath Ram was initially appointed as primary school teacher such and such on RS scheme in Keonjhar district and joined in service on 28/7/1988. While continuing as such, an advertisement was published for the post of BRCC under SS program by the state project opposite partner 1. As per the advertisement, the petitioner Sri Ram was applied for the post of BRCC and deployed as BRCC by the DPC, DPEP Keonjhar by order number such and such. That is 16/4/98. The stipulation was given in the appointment order that the candidate was deployed with his own scale of pay with
One scale of pay means they are referring to that primary teacher's scale of pay.
yes,
Yes.
and other allowance as admissible by the government. That the appointment order did not prescribe scale of pay 1700 32 up to 3200 to the petitioner. That appointment of the petitioner was temporary basis. So my as per the advertisement I was appointed. So I claim that my salary should be given in terms of advertisement.
So why did you accept it? You accepted it. That was in 1998.
Yes, but
You should have challenged it immediately.
I made request to the other opposite party. Opposite party had said that we will consider.
No, that Mr. Das, you know.
It is a recurring cause of action. Salary is a recurring cause of action.
No, not a request. Salary. It is not a question of salary. It is a fixation of the appropriate scale of pay. It's not a salary. It is a fixation of the scale of pay, which is relevant here. Not the payment or non-payment of salary. That would have been a continuing cause of action.
And any not the financial benefit.
All right. Let us see that the petitioner Sri Ram has accepted the said order. So your representation is in 2010.
10 million. That I was in service.
So that is 12 years after you joined.
I also have approached before this honorable.
When did you come to this court?
Yes.
2003. All right. But your appointment was actually, you were deputed. It's not a fresh appointment.
My appointment pursuant to advertisement. I was selected. It's not a question.
Yes. What is your counter?
Senior Counsel Mr. P.K. Mahanti Mallard. He is the special counsel.
Their advertisement.
There they?
Advertisement put by them.
OP number 2, 3 out of 4.
Yes. Mr. Pikamanti is to argue.
On behalf of
Paper. Paper.
Yes. Project Director of Paper.
He is not there.
He is actually.
On behalf of Pikaman.
So you can argue. Yes, please. What is your stand?
My word, appointment order, Annex 4.
Annexure 4 is the,
usual day and other allowances as admissible by government.
no, Annexure 3 is the appointment order. Annexure 2 is the appointment order.
Appointment 4.
Annexure
Annexure
2 is
four.
the, no, Annexure 2 is the competent authority.
Competent
He has
authority.
requested
এইটা
to
তোমার
appoint.
appointment order দেখো।
How?
সেটা তো দিলা ডিপিসি দিলা।
Dated দেখো
দেখি
16/4/98
After this.
আচ্ছা হোক ঠিক আছে কোন হলা hereby appointed as
and
DS
other allowances as administered by government to time from time to time pending sanction of foreign service terms and conditions. He is appointed as a foreign service term and condition. As usual annexure.
It's a letter from district project officer. You are reading.
No. This is project officer, is the appointment also.
Appointment in person to annex.
No. The
Anyway.
advertisement. Advertisement. Annexure 1.
did the advertisement did it allow you to appoint anybody on foreign service?
No. Those are sir 10 বছরের এক্সপেরিয়েন্স থিবে
কোড লেখা আছে কি
দেখুন স্যার যোগ্যতা
যোগ্যতা.
যোগ্যতা
Just below the scale.
ব্লক কেন্দ্র
উভয় পদবী ପାଇଁ ଅନ୍ୟୁନ 10 ବର୍ଷର ପ୍ରାଥମିକ ବିଦ୍ୟାଳୟର ଅଭିଜ୍ଞତା ଥିବ
yes
ତାଙ୍କର ଅଛି ସେ ଆସିଲେ ତାକୁ ଆମେ ଆପଏଣ୍ଟମେଣ୍ଟ ଦେଲୁ as foreign service terms କରିଛନ୍ତି
when your advertisement does not permit so
ଆଜ୍ଞା
your advertisement does not permit so
ଲେଖିଛି ସାର୍
নে 10 ବର୍ଷର ଅଭିଜ୍ଞତା ଥିବା ଦରକାର ତାଙ୍କର ଅଭିଜ୍ଞତା ଅଛି
ଅଭିଜ୍ଞତା
So here this is-
ଟିଚରସିପରେ ପ୍ରାଥମିକ ବିଦ୍ୟାଳୟର
ଠିକ ଅଛି
ଅଭିଜ୍ଞତା ଥିବ
so this appears to be a fresh advertisement a fresh selection fresh appointment
ନାଇଁ ଫ୍ରେଶ ଆପଏଣ୍ଟମେଣ୍ଟ କ୍ୟାଣ୍ଡିଡେଟ୍ ପାଇଁ ଏଇଟା ନୁହେଁ এটা হচ্ছে ଯୋଉ ଯାହାର କମିଂ ଅଣ୍ଡର 10 years ଏକ୍ସପିରିଏନ୍ସ
দেখে কোড লেখা আছে কথা
এই দেখନ୍ତୁ ସାର୍
সেটা ମୁଁ দেখছি
ଯୋଗ୍ୟତା ନାଇଁ ଆଜ୍ଞା ଯୋଗ୍ୟତା ଅଭିଜ୍ଞତା ଉଭୟ ପଦବୀ ପାଇଁ ଅନ୍ୟୁନ 10 ବର୍ଷର ପ୍ରାଥମିକ ବିଦ୍ୟାଳୟର ଅଭିଜ୍ଞତା ଥିବ
ଥିବା ଦରକାର ସେଟା ତାଙ୍କର ଯୋଗ୍ୟତା
ସିଏ ଯେତେବେଳେ ଅଭିଜ୍ଞତା ତାଙ୍କର ଅଛି ଆମେ ତାଙ୍କୁ ଆପଏଣ୍ଟମେଣ୍ଟ ଅର୍ଡର ଦେବୁ ଦ୍ୟାଟ୍ ଇଜ କଲ୍ଡ ଫରେନ୍ ଆଣ୍ଡ ସର୍ଭେଣ୍ଟ କଣ୍ଡିସନ ଫରେନ୍ ସର୍ଭିସ ଯେତେବେଳେ କ୍ଲବ ଆବୋଲିସି କରିଗଲା BRCC ତାଙ୍କୁ ଆମେ ବ୍ୟାକ୍ କରିଦେଲୁ ସେ ତାଙ୍କର ଯୋଉ ପୋଷ୍ଟରେ ଥିବେ ସେଇ ପୋଷ୍ଟରେ କଣ୍ଟିନ୍ୟୁ କଲେ ଦେଖନ୍ତୁ ତାଙ୍କର ଯୋଉଟା
ବ୍ୟାଗ ଯୋଉ କଲେ
ଅର୍ଡରଟା ସାର୍
କୁହନ୍ତୁ ଆପଣ କୁହନ୍ତୁ
appointment order ଦେଲୁ ପ୍ରାସକୁ appointment ଦେଲୁ appointment as a BRCC coordinator in a block which his own scale of pay ସେଠି ଯାହା scale of pay draw କରୁଥିଲେ ସେଇ scale of pay ତାଙ୍କୁ ଆମେ appointment ଦେଲୁ as a usual DA and allowances. Foreign service foreign service term and condition.
no you said that after abolition of that scheme he was repatriated to his parent department. Is there any document to that effect? Have you filed any document? Any order repatriating him to his parent department? Where is that document? You have? Or have you said anywhere in your counter?
Counter, sir. Counter para coach.
Counter paragraph?
Coach.
I think para 10.
They will be on deputation on foreign central condition.
সেটা appointment order এ ନାହିଁ
ନାଇଁ ଆଜ୍ଞା ପାରା ଆମର କାଉଣ୍ଟର ପାରା
ନି counter para ରେ ଅଛି ଯେ para 10 I have read it.
ଆଜ୍ଞା
I have read para 10.
ଆଜ୍ଞା
Whatever you are saying is mentioned there, but you say that the appointment in his appointment letter it was mentioned that the appointment was temporary in nature and returnable to his own post without any notice. This portion I did not find anywhere mentioned in the appointment letter.
appointment order ଆଉ କଣ appointment order ନିକଲି foreign terms and condition basis.
नहीं ଏଠି ଆପଣ ଯୋଉଟା ଲେଖିଛନ୍ତି
ଆଜ୍ଞା
ଯେ in his appointment letter it was mentioned that the appointment was temporary and returnable to his own post without any notice. ଏହି portion ଟା ତ ନାହିଁ appointment letter ରେ ଆପଣ ଲେଖିଛନ୍ତି ଏଠି ଅଛି ବୋଲି
sir ଏଇ ଗୋଟା ଆମେ ଦେଇଛୁ after closure of PEP he was returned to his parent post of level V as a primary school teacher.
So what is your reply to this? That after closure of DPP you are returned to your parent post? Yes, Mr. Das,
Rejoinder file kar.
you need to file a rejoinder. You need to respond to this paragraph 10.
But
Not further
I'll-
arguments in part.
I'll give that.
In course of hearing, it is submitted by, sir, I'm forgetting your name, sir.
Sir, Yashwant Das.
Sri S.N. Das, Learned Counsel appearing for the opposite party, number 2, that the appointment of the petitioner, though pursuant to the advertisement, was actually on deputation and deputation as per foreign service terms. Stop. After closure of the DPEP, he was repatriated to his parent post of primary school teacher level 5. Stop. Sri Das, Learned Counsel for the petitioner, seeks some time to respond to this contention. List this matter on paper cut. Chuti bolu sir. 13th May.
Item 9.
May I please, my lord? The case of the petitioner is that since 2008, he was serving as a Gram Rojgar Sevak, my lord. In 2014, a Shokas notice was issued to her. Your lordship may kindly have a look at, just to refresh my memory, my lord. Lordship may kindly have a look at Annexure 4 at page 18.
Yes.
My lord, a Shokas notice is issued to the Panchayat Executive Officer, Jayankiri, to the Gram Rojgar Sevak, Jayankiri, the present petitioner, enclosing the report of the Ombudsman. The Ombudsman report, my lord, finds at the next page, page 19. Complaints have been found. Sumoto file complaint by receiving phone call from the villager of Minuguda village, Jayankiri Gram Panchayat of Jaipur block. It was revealed from the complaint that payment has been made to 30 number of job card holders of the villages, Minuguda and Chargaon, Jayankiri Gram Panchayat of Jaipur block. Details of opposite parties have been given. Panchayat Executive Officer, Junior Engineer GPTA, Gram Rojgar Sevak Jayankiri Gram Panchayat, the Block Development Officer, Program Officer, Jaipur. But thereafter, next page, my lord would see the award of the Ombudsman. Accordingly, it is recommended that it was found that during field inquiry, spot verification and hearing of the cases, that without work an amount of rupees 25,000 some odd has been transferred to the account of job card holders that violates MGNR EGA. The Panchayat Executive Officer, the Gram Rojgar Sevak of Jayankiri Gram Panchayat, and the respective GPTA/junior engineer were found involved directly on this misappropriation, and I do strongly recommend to penalize these persons as per the Act and IPC. But thereafter, my lord, I replied to the Shokas notice under Annexure 5. My lord, and again, another Shokas notice is issued to me in Annexure 6 by the project director.
Before that, you gave a reply.
Yes, my lord. Again, once again, I replied to it.
Now, what was your reply?
My reply, your lordship would see at Annexure 5 at page 21.
Yes.
The second paragraph, my lord. As per verbal instructions of GPTA Jayankiri, the master rules bearing number so-and-so were generated in online by sanction number so-and-so and reflected payment of rupees 8,580 and in favor of 30 number of job card holders of Minuda and Charogram villages. However, payments has not been made to the job card holders and detained in post office until further orders. The amount of 25,739 has not been misappropriated as narrated. However, I do hereby beg apology for the said lapse and beg excuse. I do hereby undertake that the said lapses would not be recurred in future. And thereafter, another Shokas notice is issued to me by the project director, Annexure 6 at page 22. Once again, I replied under Annexure 7, my lord. On the same lines, my lord. On the same lines, once again, I replied to it. Thereafter, under Annexure 9, they terminate my services. My lord, my simple case before your lordship is the fact-finding authority, that is the ombudsman, he undertakes an inquiry. He comes to a finding that not only me, but there are others also who are also stand implicated and are responsible, and direct the authorities to take action against all of us. But they choose to only proceed against me, leaving aside the other delinquents. In Katina of judgments, my lord, by your lordships have held that for the same misconduct, there has to be a parity among the delinquents in the matter of punishment. But over here, my lord, they only decide to proceed against me and let aside the others. And on instructions, my learned friend has also submitted before your lordship that as a matter of fact, no proceeding has been initiated against the Panchayat executive officer and the junior engineer, but only I have been terminated from my services, my lord.
Yes.
And on the last occasion, my lord, my learned friend placed reliance on the job card of
To show that this is also part of your job.
Gram Rajgwar Sevak, my lord. My lord, if collectively, if you one reads the entire thing, it is not, my lord. Now the ombudsman has given a finding that each one of us we are responsible. And even reading of the entire thing,
Yes,
my lord,
yes.
it
We-
shows
we
that
will
it cannot
concentrate on
be, it
that.
cannot be handiwork of only one person.
No, we'll concentrate on that
Yes, ma'am.
because the ombudsman is there document. Yes, Mr. Das.
My lord, if your lordship will again, my lord, come to page 27, that the impugned order of termination, my lord.
27. Yes.
My lord, now before, my lord, passing of this order, the ombudsman recommendation was only taken as a reference point. And accordingly, he was issued so cause. The petitioner was issued the two so cause notices. Her so cause notices were examined, it was dealt with, and this order was passed. It is not that only on the recommendation of the my lord, the ombudsman, we directly disengaged her. If your lordship will see second para, my lord, whereas the ombudsman has the authority to report against the delinquent person to the collector cum DPC of the district for initiating action as prescribed in the instruction of MOD regarding functions and responsibilities of ombudsman mentioned in chapter so and so and communicated by letter number so and so. While the GRS has been issued with so cause by DRDA, Koraput, regarding the entry of false muster roll in the Narega sub on the above project, she replied the above so cause notice, but the same has not been found satisfactory. Now, as a matter of fact, what is clearly established here, that there was no such muster roll prepared by the petitioner, and the work was shown to be completed, even though the work was not at all begin, not at a start or commenced at any point of time. So this fact has not been disputed or not been challenged by the petitioner, that so far as the allegation made by the department has never been challenged. She never assails the said decision or said finding of the ombudsman that actually I have done this work and the muster roll has not been prepared by me, or the muster roll which I have prepared doesn't include the name of those beneficiaries who have been paid. This type of defense has not been taken by the petitioner, and what she has offered in her explanation was not found to be satisfactory by the department. Now, lordship will kindly see that he is not a government employee, my lord. GRS is just contractual engagement, my lord, and therefore the principle of natural justice was also, my lord, followed in this case. He was given so cause notice, and her so cause notice was not found satisfactory. Only after that, my lord. So even if other two persons, governments are, my lord.
So cause notice not being found satisfactory is one aspect.
My lord.
The other aspect, there finding of guilt must be there.
Yes.
Where is that finding? How does the collector come to a finding that yes, he is the person responsible for misappropriating the amount meant for the beneficiaries, when on the face of it there is a order of the or an award of the ombudsman, maybe a directory, not mandatory.
My lord. Recommended.
Yes, recommendation, but he has made a specific finding there that
Yes.
these people are all responsible. So now you single out this person, issue a so cause notice, and how do you? Where is the finding that whatever he has said is wrong? Last by saying that your so cause is not acceptable, will not do.
Yes, lordship is
There has to be reason.
Whereas the personal hearing of Srimati Patra GRS was conducted by the undersigned on 13 and 14 pertaining to the above matter, and her deposition was recorded. See, impugned order last but prior finding. Last but one paragraph.
Personal hearing pertaining
She
to the
could
above
not
matter,
submit
position is-
critical explanation in this.
She could not submit her
I can improve on what by this is the language my lord they have used.
गया
Without recording and constant lordship remand if you
ये गया
remand the matter to the
ये होगा नहीं.
collector for fresh
Of
consideration.
course, I'm not going to record your concession.
My lord. This is a pre-cryptic order.
There is absolutely cryptic, nothing is there. I'll set it aside, but this is a matter of the year 2014. In reopening, she has already been disengaged.
She has been disengaged, but my lord,
Is there any interim order?
yes, my lord, subject to result of the writ petition.
So you, but that is another matter. You are out of employment.
I'm out of employment.
Whatever worth.
My lord, I'm just relying on the judgments, my lord.
No. What will be the judgments?
So whatever the principle of law, my lord.
Don't.
Parity. And my respect for submission, my lord.
Parity more will negative equality.
No question of remand, my lord, because once my lord finds that the order is illegal, then
I'll set it aside.
And I have to be reinstated back in service, my lord.
I will set it aside. I'll direct him to be reinstated. It shall be open to the authorities to conduct an inquiry in terms of the recommendations made by the ombudsman.
Well, lots,
isn't it? So, the petitioner has approached this court seeking the following relief. The case of the petitioner, briefly stated is that she was, is it a lady?
Lady,
Yes.
madam.
She was engaged as Gram Rozgar Sevak. को गया था
of
जयंतीगिरी
GP.
जयंतीगिरी ग्राम पंचायत as per appointment order issued on 22/2/2008 by the Sarpanch of the said GP. Stop. She executed an agreement on 22/2/2008.
Yes, my lord.
Yes.
As required by the order of appointment. Subsequently, it was
Page 15, it was continued up to 24th February 2014.
The agreement was renewed on
24/2/2014, my lord.
24/2/2014 for a further period of
Till 29/2/2015, 1 year. Whole year.
for a further period of 1 year. Again, I would say,
Right at the 15.
how? While working as such, the petitioner was served with an inquiry report dated 17/12/2013 of the Ombudsman, MGNREGA, Koraput. Stop. Such inquiry was conducted in the with regard to irregularities in the implementation of MGNREGA in the construction of playground at Minaguda in the aforementioned Gram Panchayat. So, after conducting a field inquiry, the Ombudsman passed the following award. Accordingly, it is recommended that he page 20 quote it will be quoted. Pursuant to such report of the Ombudsman, the petitioner was asked to show cause. Where is that show cause?
No, page 22.
Was asked to show cause by the project director DRDA Koraput by notice dated 13/2/2014. The petitioner submitted her explanation, her reply addressed to the. This is another show cause.
Yes,
You have
sir.
replied to another show cause.
The previous show cause notice that Annexure 4 at page 18, my lord, including the ombudsman report.
Okay. Pursuant to the inquiry, report of the ombudsman, the petitioner was asked to show cause by the BDO Jaipur by letter dated 4/1/2014. Stop. The Panchayat Extension Officer, Panchayat Extension Executive,
Executive officer.
Panchayat Executive Officer of Jayantagiri was also asked to show cause and submit compliance report by the very same letter. Stop. The petitioner submitted her reply on 8/1/2014, specifically stating that she had as per the verbal instructions of what is GPTA?
Gram Panchayat Technical Assistant.
Assistant.
Gram Panchayat Technical
Also the
Assistant.
junior engineer.
Bracket is GPTA. Jayantagiri / junior engineer. The muster rolls in question had been generated online pursuant to the sanction order. In respect of 30 numbers of job card holders of Minaguda and Charogam villages. Stop. The payment had, however, not been made to the job card holders and was held up in the post office. Stop. As such, according to the petitioner, she had not misappropriated the amount of rupees 25,739. Hello. A further show cause notice was issued on 13/2/2014 to the petitioner by the project director, DRDA, also enclosing the field inquiry report of the ombudsman. Pursuant to such notice, the petitioner submitted her explanation by letter dated 3/3/2014, stating more or less the same facts, stating more or less the same thing as in her previous explanation. By order dated 14/5/2014, copy enclosed as Annexure 9, and which is impugned in the present writ application, the collector cum CEO, Zilla Parishad, Koraput, after purportedly considering the explanation, show cause reply submitted by the petitioner, and after personally hearing her, held that the reply submitted by her was not satisfactory. As such, she was disengaged from the post of GRS. Sir, TK aa gaya? Sir, TK. Slowly. She was disengaged from the post of GRS with effect from 14/5/2014. Feeling aggrieved, the petitioner has approached this court in the present writ application.
May I enter for a wheel? Lordship, may kindly indicate the interim order passed by this honorable court.
I will. The writ application has been filed. Let's have Sadiq. The writ application has been filed inter alia on the ground that, as per the field inquiry report submitted by the ombudsman, not only the petitioner, but the Panchayat Extension, executive officer, and
junior.
It's stuck in my mind that it is extension. There was a
Yes,
there was a
there is a post also, Panchayat Extension.
the Panchayat Executive Officer and GPTA, GPT were also responsible for the irregularities in the matter of payment of wages to the job card holders. Stop. Counter affidavit has been filed on behalf of opposite party number 1 and 2. Mainly stating that the petitioner was found to be involved in the irregularities committed in the MGNREGA work relating to construction of playground at Muniguda. Stop. The field inquiry report of the Ombudsman clearly shows the complicity of the petitioner. It has been further stated that the petitioner was not the holder of a civil post, and therefore the rules therefore the procedure to be followed in case of misconduct committed by the government employees is not required to be followed. Stop. In the instant case, the principles of natural justice were followed by giving opportunity to the petitioner to show cause twice. Stop. Her explanation, her show cause reply was found to be not satisfactory, for which the collector, being the competent authority, rightly decided to disengage the petitioner from service. Para. Heard Sri Rajit Roy, Learned Counsel for the petitioner, and Sri S.N. Das, DS, Learned Counsel appearing for the state in these matters.
Statement.
Appearing for the state in what? MNREGA matters.
Special, as AC several lots mein.
How? S.N. Das, Learned AC for the state.
I'm for OP3 in this case.
Who are you?
I'm for Sarpanch.
You have nothing to do in this
Yes,
case.
sir. But I
And
will.
Sri, yes, I will write your name.
Oh,
And Sri M.K. Mahapatro, Learned Counsel appearing for the opposite party number 3. Para. Sri Roy would argue that the report of the field inquiry report of the Ombudsman, a copy of which has been enclosed as Annexure 5.
Annexure 4, my lord.
Annexure 4 clearly reveals that the Panchayat Executive Officer, the Gram Rozgar Sevak of Jayantigiri GP, and the respective GPTA/JE were found to be involved directly in the matter of misappropriation, and therefore recommended the authorities to penalize them. So, as such, the petitioner alone could not have been selected for punishment. Stop. You are citing this Rajendra Yadav.
First is Mansingh versus State of Haryana.
No, this is in general terms. Acha.
No, my lord.
Acha. Sri Roy has relied upon the decision of the Supreme Court in the case of Mansingh versus State of Haryana and others,
Paragraph 20 and 21.
2008, 12 SCC 331, wherein it is held that the there cannot be any discrimination by the state as between employees in the matter of imposing liability. Stop. I'll quote it again. Sri Roy also relies upon
Same principle, my lord. Rajendra Yadav versus
The-
State of Madhya Pradesh.
judgment of the Supreme Court in the case of Rajendra Yadav versus State of Madhya Pradesh and others, which is on the same lines.
9 to 12.
Yeah, I'll quote it later.
The last one is that even in contractual matters where there is perversity, there can be scope of judicial review, madam. Paragraph 26.
Not necessary. Not necessary at all. Look, Sri further argues that even otherwise, there are materials to show that the amount in question was never misappropriated, but detained in the post office,
Yes,
which the authorities have not looked into. Full stop. Sri Das, on the other hand, while opposing the contentions raised, would argue that the award of the ombudsman is in the form of a recommendation. It is in the form of a recommendation only, and not binding on the authority concerned. Stop. Further, the petitioner was called upon to explain not once but twice, comma, which she failed to do. Stop. That apart, by citing the stop. Nothing has been stated on behalf of the state opposite parties as to why, on the face of such report of the ombudsman, comma, the petitioner alone was singled out for action. Stop. In the case of Mansingh Supra, the Supreme Court, reiterating the principle of equality enshrined under Article 14 of the Constitution of India, observed as follows. Para 20 or 21 quote karo. Similar view was taken in the case of Rajendra Yadav Supra by observing as follows.
9 to 12.
9 to 12. 9 to 12. Yes. Thus, the legal position as it stands is clear to the effect that no person can be discriminated by the state. No person can be discriminated, comma, particularly by the state in its actions. Stop. If several persons were found to be jointly responsible for the irregularities, comma, it is only fair that all of them should face the consequences. Stop. By singling out only the petitioner, it would appear as if the state has allowed the other persons to go scot-free, even though, as per the ombudsman report, they cannot be held to be definitely innocent. Stop. That apart, the reading of the impugned order does not reveal as to why the show cause reply submitted by the petitioner was not found satisfactory. Stop. It is straight law that the order passed by a quasi-judicial authority is required to be backed by sufficient reasons, as otherwise it becomes vulnerable. Stop. This court also notes that personal hearing, opportunity of personal hearing was granted to the petitioner. But then what transpired out of the said hearing has not been indicated in the impugned order in the least. Taking into consideration, what was your stand? One stand that you took was opportunity was given. No. I would
The
call
fact remains that she has although the recommendation was there against all the public servants, but the petitioner's involvement so far as preparation of master will, that is not denied. She only claims that money has not been transferred, but her role so far as preparing that.
it is still open. I will grant that liberty. Yeah. Tara. Thus, from a conspectus of the discussion made on facts and law hereinbefore, this court is left with no doubt that the impugned order suffers from the vice of non-giving of reasons and also strikes at the principle of equality enshrined under Article 41 of the Article 14 of the Constitution of India. The input order is therefore rendered is held to be unsustainable in the eye of law. Para. In the result, the writ application is allowed. The impugned order under Annexation 9 is hereby quashed. The opposite party authorities are directed to reinstate the petitioner in service, reinstate the petitioner as GRS of Jayantagiri Gram Panchayat.
In the meantime, one more person is working there, Your Lordship, since 2014.
Jayantagiri Gram Panchayat or in any other any other Gram Panchayat of Koraput district as early as possible, preferably within a period of 2 months from the date of production of certified copy of this order by the petitioner. Stop. It shall be open to the concerned authorities to conduct further inquiry in the matter against all persons responsible as per the inquiry report of the Ombudsman and to proceed accordingly. Yes. I do not tend. बताओ ना, बताओ देखिए अपने सुविधा को इसे देखिए करिए कोटेशन करिए. Yes, Mr. Pratap, what is this? We have to close it. We are
Only direction has been given to my friend to take, to bring the
original notification. Original notification of defining the service area of Kharnagar Mini Anganwadi or the original office copy of the advertisement dated Solbar. You ready? Both. Very good.
May I permit it to place?
Please.
My lord, to consider the facts, my lord. May I pray lordship to go to the competitive prayer, my lord, in the writ petition.
Was the order dated 16/2018?
Order passed by the ADM Kendrapana in Anganwadi, Miss Appeal number at Annexure 1. Now I am taking a lordship to the Annexure 1. The relevant person, my lord, pay no 5. Thereafter, pay no 6. The pay no 5 is the averment of the present petitioner. My lord, who was the respondent in that case as respondent number 2 in the appeal.
Also correct. This appeal was filed by
the other person who could not succeed in that.
The client of my friend. Yes. So
and
this
the
appeal
petitioner in the present case, my lord,
is
he
the
was
opposite
the respondent number 2. My lord, page no, internal page number 6, my lord.
Yes.
As per the observation of the Hon'Ble High Court, now it is to be decided whether any manipulation and tampering has been made in the notification at the instance of the CDP or database. 1, then 2, my lord. The actual name of Mini Anganwadi Center as per the original notification. Then 3rd, the area of operation of the Mini Anganwadi Center. These are the 3
practically जो कथा था मुझे कही.
Now, my lord, from the now what is the view what it has been taken, madam? From the joint inquiry report of the DSW Kendrapada and the CDP of database, it is clear that the original name of the Mini Anganwadi Center is Khannagar. it has been manipulated and tampered in the
At the
instance of
instance.
CDP or database. This court has clearly mentioned the fact of manipulation in his order dated 24/10/2013. The Purba jo report is. Therefore, the DSW of Kendrapada is directed to cause an inquiry into such manipulation and take appropriate action against the person at fault. As per the joint inquiry report, the respondent 2 belongs to Majipada.
Mojipoda.
Yes, sir. Majipada Hamlet, which is coming within the territorial jurisdiction of revenue village of Pathamur. The resident certificate issued by the Tahsildar Derabis by Mishkesh number also corroborates the same thing. Therefore, it is clear that the respondent number
Sanjukta Dadi.
respondent 2 Sanjukta Dadi belongs to Hamlet Majipada under Ortamul revenue village. Further, the area of operation of the mini Anganwadi center is only village Khannagar. So these are the two specific findings. As such, the respondent number 2 is not coming within the jurisdiction of area of operation of the mini Anganwadi center Khannagar. Therefore, the candidature of the respondent number 2 was required to be rejected at the time of scrutiny. But as stated above, due to the manipulation tampering in the advertisement, the respondent number 2 Sanjukta Dadi got engagement as Anganwadi worker in Khannagar mini Anganwadi center. For that reason, my lord, therefore the appeal is accordingly allowed. So, my lord, now, because this was the view, the lordship wanted to see that what is actually the name of the Anganwadi center as it has been created, a mini Anganwadi center as it has been created, and whether any service area has been defined there or not. And third thing, my lord, since there is a question of tampering of the advertisement, where is the original advertisement? Now, my lord, in the meantime, my lord, there are 3 to 4 correspondences and 3 to 4 time different documents have been produced. Now, my lord, I have received one file mail, where on verification, my lord, I have found that with respect to that chart, my lord, there is a committee. That committee is actually, my lord, is actually responsible to prepare the service areas, where there is a proposal for creation of any mini Anganwadi or additional Anganwadi center. That chart, my lord, there it Ortamula is there, Khannagar mini Anganwadi center is there, my lord. With respect to the service area, just above Khannagar, maybe afterward, my lord, or something like that. But the original file, what it has been produced for me, Majipada, is there.
Flag Marat. Do you have flags?
What's sir?
You don't know nothing. What about pocket to go flag bar? Sarkar flag
So this is the first submission, my lord. With respect to availability of
but then the finding of the ADM that it has been manipulated and tampered at the instance of CDP database, so there must be an inquiry. What was the result of that inquiry?
Yes, see, inquiry they came to a conclusion that the petitioner in the present case.
No. Inquiry as to manipulation.
Say
Therefore, the DSW of Kendrapada is directed to cause an inquiry into such manipulations and take appropriate action against the person at fault. So, what action, what inquiry, what did that further inquiry reveal?
Well, I'm just clarifying these two positions, what it is available now.
Okay.
Well, I'm not in support to
Mr.
defend the case of the ADM.
I understand.
Well, because
the ADM has seen the document which you are showing to the court right now. This is what the ADM says.
After 3 to 4 times of effort, my lord, I could get this particular document, whether this particular document was taken into consideration by the ADM, my lord, I can share.
All right.
My lord, second thing, my lord, I also got the copy of the original advertisement.
What does it mention?
My lord, the original advertisement containing the signature of the CDP in original, that also, my lord, says that in fact, my lord, while preparing the DTP with Khannagar, the name of the Anganwadi center, there was a mention of Majipada. So that was corrected. And thereafter, my lord, in the service area, Khannagar was only written, my lord. But the
Standard
original advertisement, what is now available in the file, that says Khannagar Mojipada with initial. So I'm also flagging it.
Let's flag it.
So, my lord, what a specific question was put to me, my lord, that whether these things were taken into consideration or not, and what is actually available in the original file. My lord, the original file contains that the service area name is mini Anganwadi service area, or mini Anganwadi center's name is Khannagar, and the service area covers, my lord, Mojipada with Khannagar. Because now this is the file, what original file they have provided to me, my lord.
But the collector has filed an affidavit saying that the area of Mochipada doesn't come under the service area of Khannagar mini ADVs.
On verification, my lord. Because there was a direction.
It has to be inquired again, though this court will not enter into this factual controversies. It has to be, inquiry has to be conducted. I'll dispose of directing inquiry to be conducted. Status quo be maintained? How can this court come to a finding? Tell me, Mr. Patra. Mr. Pratap. How can this court, sitting in 226, come to a finding whether there was a tampering or not?
In the count, your lordship may just see the counter.
No, the counter is misleading. This affidavit I should read out.
Basing upon that counter, they have filed affidavit. The affidavit they have counter.
What do they say? They say that that area of Mojipada doesn't come under the service area of Khannagar. Here they mention it Khannagar, Mojipada, and sign it. There in the original file, there is only Khannagar.
No, Mojipada is there.
Mojipada pa sidra interpolation ହେଇଛି?
ସେମାନେ କହୁଛନ୍ତି କିନ୍ତୁ
in original file Mojipada is there.
So this collector's report, is it not now?
It is a fact-finding report on the basis of the report of the Tahsildar.
That. So he is submitted on affidavit.
My lord, there was a direction by this honorable court in the previous occasion
Yes.
to cause an inquiry and to submit that report, and that particular report shall also be taken into consideration at the time of disposal of the appeal. So that was the action taken by the collector, my lord, and that report had been taken.
But that affidavit now is on a different point altogether. So this court will never enter into this mess.
Actually.
This is a mess now. It has to be inquired into by a high level authority.
My lord, I am submitting one.
You don't have to submit anything. This is a matter between the court and the state now.
So
I know, Mr. Pratap, you have a difficulty in the sense that the status quo is in his favor.
Yes, Minister.
That is true. But otherwise, as it is, nothing can be done by a writ court. Unless there is a clear-cut finding.
at a specific time may be fixed.
Okay, obviously, 1 month, 2 months after the elections, keeping the elections in mind, so that he can get a further cause of action, if at all, to challenge that finding. But it has to be by a senior officer, not even the collector. Not even the collector. This is in a very serious mess. I'll pass orders accordingly. I'll go through the files and I'll pass order. Yes. I'll pass order. I'll direct, who can be directed? RDC?
RDC, better method, RDC. RDC Central.
RDC Central with the direction to conduct inquiry himself.
Yes.
Not deputing it, I'll make it very clear that he cannot depute it to the collector or Tahsildar or anybody. He has to cause the inquiry himself and submit and give a finding either way.
Yes.
Which either of the parties being aggrieved by challenge. No, Mr. Pratap, you tell me. Yeah, it is true that this order will be against you. But tell me what further order can this court pass? On the face of such conflicting affidavits and conflicting, it becomes purely disputed questions of fact.
May I play one? According court may direct to take action against the person who has filed false affidavit before this honorable court.
No, that will come to picture subsequently. When there's a final definite report, before the it will be open to you to make that prayer.
Only sir 5 ବର୍ଷ ପଳେଇବ
5 ବର୍ଷ କାହିଁ ଯିବ? 5 ବର୍ଷ କାହିଁ ଯିବ?
18 ରୁ sir 24.
18 ରୁ 24 ଗଲାଣି ସେଥିରେ ସେ ଭୁଲ ଆମର.
Is very much our
No, but Factual finding, how can this court enter? How can this court? I mean, it will be sitting in appeal over the factual finding of the ADM.
Yes, মানে
That will be very.
মানে report is telltale minute. কারণ the affidavit is false. As per the report is affidavit is false.
No, so a collector, being a senior government functionary, has relied upon the Tahsildar's.
No, your lordship may see one point. The report of the collector basing upon the inquiry report of DSO. Kindly have a glance the order of the report of the DSO.
No, I will not go. My hands will become dirty. Yes, the lemon I do cheat order. It's other okay. So Rockile very Oswida Piru. Some cases are like that, Mr. Pratap. Very difficult. As directed,
The both shadows are deleted.
the Sri S.N. Patnaik learned AGA has produced the original file containing the
যেটা হচ্ছে committee report on the on determination of the service area.
containing the report of the committee regarding determination of the service area of different Anganwadi centers of
Mini Anganwadi, sir.
mini Anganwadi centers of
Both.
no, Anganwadi and mini Anganwadi centers of Kendrapada district.
Oh, yes, yes.
Of Kendrapada district. He points out that the service area of
Hannagar, madam. I think that is just middle, madam. Or
Hannagar,
yes,
mini Anganwadi center ଏଇଠି ପା ଖାନନଗର ମଝିପଡ଼ା ପୁଣି ଲେଖା ହେଇଛି is mentioned as Khannnagar, Mojhipada. This court has also perused the
advertisement.
Has also perused the said document being produced in the court. Sri Patnaik has further produced the original advertisement dated
Original advertisement dated
16/12/2009,
Yes.
wherein the service area is mentioned as Khannnagar, Mojhipada, with initial
Yes.
with initial of someone.
Initial of CDP.
How do you know that? How do you know that?
Oh,
How
sorry.
will this court know?
Sorry.
Why will the court give a finding?
Sorry.
The name of the mini Anganwadi center is mentioned as Khannnagar, and the words Mojhipada appear to have been scored out. Has been scored through. As compared to these documents, the affidavit filed by the collector, filed by the collector Kendrapada on 16/2/2023 is to the effect that Mojhipada does not come under the service area of Khannnagar mini AWC. This court further takes note of the impugned order under Annexure under Annexure 1 passed by the ADM, wherein he holds as follows. Tadre quote karantu para page number 6 ru mane internal page 6 ru jo from the joint inquiry report lekha achi seta pura quote karantu. Stop para. It is quite obvious that the facts as regards the facts are not clear at all, in as much as there are materials to show that Mojhipada is included within the service area of mini Anganwadi center, Khannagar mini Anganwadi center. Whereas it is also stated that the same is because of manipulation, purportedly at the instance of CDPO database. The report of the DSWO Kendrapada, there seems to be a report
Yes, my lord.
Annexure,
the DSWO Kendrapada at Annexure,
my lord.
9 of the
Take that
petition.
Annexure C/2, my lord.
Annexure C/2 to the counter. As per which Majipoda does not come within the service area of Khannagar mini Anganwadi center. Stop. Nothing has been stated as regards the so-called manipulation of the original notification / advertisement. Stop. It is evident that the writ application contains the writ application involves seriously disputed questions of fact, which ordinarily this court would be slow to entertain and adjudicate upon. Stop. Considering the submissions of the parties, this court is of the considered view that the matter requires further inquiry in order to arrive at a definite finding. Stop. Since the collector has already submitted a report in the form of an affidavit, basing on the report of the Tahsildar, which does not appear to be prima facie acceptable to this court, it would be in the interest of justice if any higher authority is entrusted with the task of conducting a detailed inquiry. Stop. The writ application is therefore disposed of with direction to the Revenue Divisional Commissioner, RDC is not a party, but the direction can be given. RDC, Central Division Cuttack, to conduct an inquiry himself without delegating it to any other functionary. Stop. The terms of inquiry would be, the scope of the inquiry shall be to determine, one, whether Majipoda is included within Khannagar mini Anganwadi center, and if whether there has been any manipulation / tampering in the original notification fixing defining service area of
Khannagar.
Khannagar mini Anganwadi center, as also the advertisement dated 16/12/2009. No. Such inquiry shall be conducted. So the inquiry shall be completed within a period of 4 months. 4 months. Election to
election sorry June 1
3 months kar 3 months. That's all.
may add 3 months positive.
3 months positive. Telling which it shall be open to Mr. Pratap to file a contempt. Status quo as on date with regard to the engagement of mini Anganwadi workers shall be maintained. It may be interpreted in any manner, you know. Yes.
Item number 11.
My lord, the writ application was filed by the person who was continuing as a junior clerk of the school. When the question of providing granting aid came into existence, proposals were submitted before the district inspector, district education officer, and also the director for approval of the post and for release of granting aid. At this juncture, I would show that number of documents that the school and the managing committee submitted the proposal recommending the name of the petitioner for approval in the post of junior clerk. That is the sole post available in the school. The opposite party number 7 filed an application before the opposite party number 3. Opposite party number 3, challenging that he was continuing at the post of junior clerk being 1. His case should be considered because his name has not been recommended. Your Lordship can have a look to that when the matter was heard by the opposite party number 3. Coming to know that the petitioner that some application is moved before the opposite party number 3 for consideration, he filed an application for intervention and to be heard. And when the matter was not taken into consideration by him and order has been passed, ignoring the petitioner to be heard in the matter, the writ application has been filed. To appreciate the fact of the case, my lord, can have a look to the prayer made by the petitioner, quashing of Annexure 7 at page 47 and Annexure 8 at page 40. Annexure 7, 46, Annexure 8 at page 47.
Yes.
This is 25th of January 2007 to 2012 as Annexure 7 is concerned. A letter communicated by the Deputy Director to the Inspector of Schools Management Circle as it was then. In inviting a reference on the subject noted above, I am directed to say that the claims of the following claimants of Poradio Girls High School, Poradio, stands justified as ascertained from the inquiry report of the Joint Director, Regional Director of Education, Bhubaneswar, and suggestion has been given. Your Lordship can have a look to Annexure 6 at page 43.
Yeah, before that, can you say this matter was before the regional director?
Yes, Madam.
At whose instance?
At the instance of opposite party number 7.
Opposite party number 7. Why did you go to the regional director? Because he was denied.
Because he said that recommendations were made by the managing committee taking the petitioner as the junior clerk. His name was not recommended.
So he challenged it.
He filed an application there.
So Annexure 6 is a intervention application.
Intervention application. Your Lordship can have a look to what was written that was on 30th of September 2011.
Yes.
The intervening petitioner was appointed as a clerk by the managing committee of Poradio Girls High School and has been continuing as such. The intervening petitioner has come to know from the notice issued by the Joint Director of Schools, the Regional Directorate of Education, bearing number this dated 12/9/2011, that on Rupesh Kumar Barik, that is opposite part number 7, claiming himself as the clerk of the school, has filed a petition before the Regional Director of Education, Bhubaneswar, and the said matter has been fixed for hearing on 30/9/2011. That it is respectfully submitted that to the best of the information of the intervening petitioner, Sri Rupesh Kumar Barik is not continuing as the clerk of the institution, and the intervening petitioner is continuing as such. The intervening petitioner is going to be substantially affected if the intervening petitioner is not being given an opportunity of hearing while deciding the case of Rupesh Kumar Barik. Therefore, the intervening petitioner is a necessary party, and for the ends of justice and for the proper adjudication of the case, it is a proposal for approval, so that approval after being made, grant would have been released.
Actually, when did it become an education institution, aided education institution?
My was that notification either there.
But since I found that it was the recommendation was for granting aid as per GIA order 2008. That prompted me to raise this question.
Yes,
Because,
fine.
all right. I thought probably.
Because some institutions were declared block grant institutions in 2008 were not covered under the granting aid order of 94 and 2004 block grant.
Could be, it is possible.
Yes. My only omission is
your intervention application was
not considered, direction has been given.
Let us see.
It was there before the director, and director did not consider the matter, recommended the case for opposite party number 7. Though I was present, though I made mention, and all the documents, your lordship, I will be placing it, starting from annexure 3.
No, but whether your intervention application was pending or not, what is the state's response in this regard?
State has filed an affidavit.
Yes.
On 8/1/2024.
Yes, additional
disclosing about the inquiry which was before the joint director. There, in fact, the management having not appeared, the difficulty in finding out the person.
My lord, for ends of justice, can my lord call for the record of?
I will.
So that your lordship can, if that can open the, what was the?
Because you find, I find that it is in that report itself you say, to the effect that one Sri D.N. Ratha was appeared on behalf of the petitioner in the aforementioned inquiry.
Yes, he has written it. Of course, in one D.N. Ratha advocate was there. D.N. Ratha advocate as if something stranger D.N. Ratha was there before them. High Court. कौन सर डिस्ट्रिक्ट एजुकेशन अफसर कौन एजुकेटेड लोग कौन है बड़े इलेक्शन?
No, he is the district education officer. Does not mean that he is educated.
I'm obliged, my lord. Holding a post doesn't mean that he is educated.
Yes. So we'll call for the file?
Yes, my lord.
Because his entire case, because I'll not go into those facts.
Yes, ma'am.
His entire case seems to be resting on that particular thing that my intervention application was on record on 39/2011, but it was not
considered.
Yes, Mr. Shekhar, what do you want to say?
Rightly point out that with regard to the maintainability of the writ petition, because I
not maintainability of the writ petition.
I approach
not maintainability of the writ petition. Maintainability of your application before the director.
I am on the point of maintainability of the writ petition as well, Your Lordship.
Why?
Because from the prayer itself, Your Lordship may kindly see the prayer at page 13.
Yes, 7 and 8. Quashing 7 and 8.
Quashing 7 and 8. And the Honorable Court to direct the OP3 to conduct an inquiry afresh, giving due opportunity to parties, more particularly the petitioner, and by considering the documents filed by the respective party to take a decision pertaining to the approval of junior club of the school. Since the claim of the petitioner is relating to his approval, the appropriate forum is for him to approach the learned tribunal under section 24.
This flows from Annexure 7 and 8. He has not directly come to the court seeking an approval. There he could have made such a...
And so far as
No.
I approached the regional director challenging my illegal removal, Your Lordship, not regard with the prayer for my approval.
From the record itself, what you challenged?
Since heard Sri J.K. Ratha, Learned Senior Counsel, appearing for the petitioner with Sri D.N. Ratha, assisting him, and Sri A.R. Das, Learned AG, stop. Also heard Sri S. Shekhar. You are Mr. S. Shekhar? Yes, Shekhar, Learned Counsel, appearing for the private opposite party number?
7.
Stop. It appears that the main ground of challenge to the impugned order passed by the director or regional director? Regional director. Is that the application said to have been submitted, application for intervention said to have been submitted by the petitioner on 30/9/2011 before the regional director was never taken into consideration, nor the documents enclosed thereto. In view of such submission, this court would like to peruse the original file of what is that, appeal or whatever you call it?
My lord, they give a number, but they give a particular number.
Original
GRCP.
Original file relating to GRC reference number 865/259 of the regional director, secondary education.
My lord, regional director, My lord, is a joint director in the regional directorate of education Bhubaneswar.
Signed by the
Opposite party
joint
number
director.
three.
Yes, yes. Okay.
Signed by the joint director.
Joint director. In the office of
Right, opposite party number three.
opposite
Because
party
I'm
number three.
discussing-
will be. Opposite party number three. Then state council shall do the needful in this regard. Let this matter on 20th May. Item number 12.
Item number 12, my lord, on behalf of Mr. Dayanand Mahatra, my lord, matter may be taken up next week.
Again?
Matter may be taken up next week, my
Right.
lord.
2012 matter.
Yes, my lord.
Right.
My senior
Copy of the
is,
affidavit filed by the university served upon land counsel of the petitioner in court who wants to go through the same and respond. He is to respond. Yes, affidavit.
yes, my lord.
So
My senior is not available. He is gone to AIMS because of his
he's gone to
AIMS.
Hospital.
Some difficulties is there.
okay, if he's asking for on his personal illness.
He's
Next week
asking
or-
time for health ground. I have no objection.
Yes, yes. So health ground.
So many times he has taken time.
health କଥା କିଛି କହିହବ health କଥା କିଛି କହିହବ ଆଜି ଭଲ କାଲି ଖରାପ ହେଇଯିବ
Already petitioner has retired from service.
କଣ କରିବା ଆଜ୍ଞା ସେ ତ ରିଟାୟାର୍ଡ କିନ୍ତୁ ୟାଙ୍କ ଦେହ ଖରାପ ହେଇଗଲାଣି କି ଦେହ ଖରାପ ଟାକୁ ଦେଖିବେ ନା ଆପଣ therefore adjournment is made on behalf of Sri Dayananda Mahapatra on the ground of his illness. Let this matter next week. Since this is a matter of the year 2012, learned counsel for the parties are requested to come ready for final disposal. Next month. Next month.
Monday.
Monday.
No further adjournment.
Yeah. Item 13.
Item 13, your lordships, I had to file one amendment application. But I couldn't make contact with my client. Therefore, I couldn't file that amendment.
Sri Mahapatra and counsel of the petitioner requests for adjournment on the ground that he could not contact his client, for which the application for amendment has not been filed. Could not be filed, sorry. List this matter next week.
Not need more time.
No. 2013 matter, I have already granted you time, Mr. Mahapatra. You cannot say that I have not granted. 2013. Yeah. Next week, the amendment, application for amendment, if any, be filed in the meeting. No. Yes. Item 14.
14 already got the service, madam. As per counter,
my lord.
counter,
Indicate
the appointment order is annexed.
So it has become infructuous?
That is one.
Lost me dispose of.
Dispose of as infructuous? It is submitted that the relief sought for has already been received by the petitioner in the meantime.
The petitioner counter is removed.
As revealed from the counter.
See, we got affidavit with the.
Affidavit written je withdraw kariye boli. Withdraw kariye.
On the counter, hence the writ application is disposed of as infructuous. Item 15.
15, my lord, on the death of the petitioner, the husband has been substituted, but some amendment is required as the prayer of the writ petition. So let it become, I have informed the.
The husband has not been substituted?
Because.
Consolidated cost, Harrier fine.
Harrier.
Right.
So you're saying, though filed the rejoinder, but some amendment is required in the.
Amendment of what?
Prayer.
Initially, he challenged his retirement at the age of 60.
60, at the age of 60.
But in the prayer portion, he said that he should be promoted to post of assistant professor. So prayer, challenge and the prayer.
1 week time, though.
Amendment.
Already I have been informed.
As requested, list this matter next week to enable the petitioner to further amend his writ application.
In the prayer of the writ.
I'll say writ application.
Right.
You make your own.
Yes.
But that's all.
Other than Monday. Because.
Monday. 13th May. Item number 16.
Maybe lots. Is the lordship's direction the last occasion to take instruction?
Oh, or Anganwadi helper.
Yes.
It was heard. The notice of hearing of the appeal. Yes, yes. She says that she was, a notice of hearing of the appeal was never issued to her. And she has specifically said so in her
Page 13 of the
paragraph 13 of the writ application. You have never denied it. That's why I wanted to know.
Yes.
What do you find? Whether notice was sufficient? देखिए तो
I have received the file, my lord, on 20th March 2015. The first date, my lord, where the notice was issued. Then case was posted to 8/4/2015. Then on 8/4/2015, the order speaks like this, madam. This case is put up today, SR of notice, not back. Thereafter, my lord, appellant is present hard. Respondent is absent on call.
ସେଇଠି ଭୁଲ ହେଇଛି ସେଇଠି ଭୁଲ ହେଇଛି
ତାପରେ ପୁଣିଥରେ କୁହାହେଲା ଯେ ଫ୍ରେଶ ନୋଟିସ
ଦେଖେ ମୁଁ ଦେଖିଦେଲି ସାଙ୍ଗେ ସାଙ୍ଗେ ଜାଣିଦେବି
ତା ଫ୍ରେଶ ନୋଟିସ ନେଲା ପରେ
କିଛି ହେଇନଥିବ ଏ ଜଣା ପଡିଗଲାଣି ଆଉ
ମୁଁ ସେଇଟା
ଏ ମୂଳରୁ ଜଣା ପଡିଗଲାଣି Mr. Das, you are appearing?
What's up?
You are appearing?
Yes, I am appearing for the beneficiary of this.
So private of this. କଣ ହବ ନୋଟିସ ଯଦି ହେଇନଥିବ କଣ ହବ?
That I have to address your lordship.
ନା ନା ମୁଁ ଦେଖିବି ନା ମୁଁ ଏଇଟା ଦେଖିଲେ ଏଇଠୁ ଦେଖିଲେ ଜଣା ପଡିଯିବ
I have to address your lordship.
Issue notice to both the appellant and respondents to appear before the court on 26/3/2015. Likely respondent is found absent on calls, but whether notice was issued or not is not forthcoming.
ସାଇଡ୍ ରେ କେବଳ ସିଗ୍ନେଚର ଟା ହେଇଛି
That is-
ଅପିଲେଣ୍ଟ
Yes?
ସେ ଯୋଉ ଅର୍ଡର ସିଟ୍ ରେ ସିଗ୍ନେଚର ଟା କେବଳ ହେଇଛି ଅପିଲେଣ୍ଟ
ତାପରେ this case is put up today, SR of notice not back from
ତାପରେ ଫ୍ରେଶ ନୋଟିସ
not back. Prayer granted, appellant is found, heard, respondent is absent on call, issue fresh notice to the respondent to appear before the court. Order not ready. ତାପରେ ତ order not ready ଆଉ ସିଧା order ହେଇଗଲା ଦେଖିଛନ୍ତି
Notice has not gone.
ନୋଟିସ ତ ଇସ୍ୟୁ ହେଲାନି ଆଉ ଡାଇରେକ୍ସନ ହେଲା ଦେଖନ୍ତୁ
I will just address.
ଦେଖିଛନ୍ତି you will be in a better position to
No, I'm submitting with that your lordship has seen.
Mr. Das କଣ ଆପଣ ଦେଖିବାକୁ କଣ ମାନେ ଆପଣ ଦେଖନ୍ତୁ ଦେଖିଲେ ଆପଣ ନିଜେ you will be in a better position to assist the court. ये ଗୋଟିଏ ଅର୍ଡର ଦେଖନ୍ତୁ ତାପରେ ତ ଅର୍ଡର ପାଇଁ ରଖିଦେଲେ ଆଉ
ଦିଆ ହେଇଛି ସାର୍ ଏତିକି ଫାଇଲ କିନ୍ତୁ ଧକ୍କା ହେଇଛି ସେତିକି It's a case matter relating to that engagement of a helper as against the post of the.
So what will happen? Now the matter has to be heard again, that's all. Did you see Mr. Das? So notice how in.
SR of notice back ऊपर not लिखाई तले.
Not लिखाई सीधा कहीं हमें why should we? तापरे सीधा रह गया जो फ्रेश नोटिस तापरे लाइन लिखा है ना
4-5 रे order pass.
order ହେଇଗଲା.
But let me address your lordship.
Yes.
Your lordship may kindly permit me.
No, ordinarily at this point,
Not regarding that.
no, what I'm saying is ordinarily at this point, I would like to set it aside and send it back for rehearing of the appeal. After granting opportunity of hearing to both.
The selection relates to 2010. My lord, there was an advertisement.
You are in now you are appointed.
Yes, I am affected because I have been selected. I have been kept out of zone of journey, and I am a handicapped person. Initially he was selected. Her selection I challenged. Her selection I challenged because the marks allotted to handicapped person that was not extended. So under annexure 4, relief was granted. You lordship may kindly see for a moment. Page 44.
Now what can be done? Tell me.
Yes,
In this
page 44, my lord, the relief pertaining to merit was granted. Kindly see, your lordship may kindly appreciate, really pertaining to merit was granted. I was selected. Under 44. The marks were added. 3 persons, 1 quitted, 2 persons are there.
That she challenged in an appeal.
That I am coming. 2 persons. I secured the highest mark when the benefit was granted to me, when the decision pertaining to merit under Annexure 2 was passed. Annexure 2 is pertaining to merit, not challenged by them. It is set at rest, your lordship.
So what is the appeal then?
That I am coming. Your lordship has rightly asked that I am coming. So Annexure 2 is set at rest. When it was not worked out, implemented, I approved this honorable court. This honorable court said that you go and file the appeal. While deciding the appeal, my lord, the appellate court has conducted inquiry that added strength to the merit. That's a different. Even if that would not have been, that's a different. But appellate court said that let her be disengaged, my client would be engaged. That is in essence implementing Annexure 2, which has been set at test, not challenged by them. Your lordship may kindly appreciate the same. So if now it would be remanded, my lord, I would make a prayer before it is to be confined specifically to the implementation aspect.
No,
it can take a somersault.
No, I don't.
I have an objection. May I clarify that position?
No.
My lord, the
let him complete then. Let him complete, then you can make it.
So your lordship may kindly see page 44.
I am looking at page 44.
The CDPO Ulunda has also admitted the fact that mark physically disability certificate has not been added in favor of Kumari Kunimahapatra, my client. So after hearing the both parties and perusal of documents, I am of the opinion that the selection committee did not add mark of the physically disability certificate in favor of Kunimahapatra, my client. Issue direction to CDPO Ulunda to add the mark for disability certificate of Kunimahapatra in the merit list of selection of Anganwadi worker of village Lehdi 2. The case is hereby disposed of. Return the relevant document to CDPO Ulunda produced by our pronouncement. So, this is the order pertaining to merit. My lord, this was supposed to be worked out. This is set at rest. They have not challenged, my lord. They are affected by it. Suppose I have not filed the appeal, your lordship may kindly see what is the position. Now also I could have come before your lordship, or your lordship appreciating the position could have directed with all respect for implementation. This requires implementation, and I approach this honorable directly for implementation in essence, and it was directed to file the second appeal. My lord, nomenclature, other things are not barred. In essence, my lord, my approach to the Honorable High Court for implementation this order under Annexure 2, which has been set at rest and not challenged by them at their instance. In my appeal, my lord, my appeal is confined to the implementation aspect, nothing more, and it has been ordered in that way under Annexure 3. Then if it would have been noticed by lord, what would have been his possible defense? Your lordship may kindly examine, or if your lordship would kindly appreciate.
You are very right. You are very right. The question is, you have filed an appeal. You actually came to this court. This court, rightly or wrongly, secretary said, remanded the matter, granting you liberty to file an appeal.
Yes, my lord.
Now you filed an appeal. Let us see where is that order, impute order?
That is Annexure 5, no 3. Annexure 3, Bharat.
3, my lord.
Annexure 3. Annexure 3.
Challenging the inaction of the opposite parties for selection of Anganwadi.
Yes, sir.
Right. So it goes without saying that it has to be confined to the grounds raised in the appeal. It doesn't. This court doesn't have to say so. Doesn't have to say so. If she, you are right. You apprehend that if a chance is given, then she will challenge the other earlier order. She cannot. It is open to her. Otherwise, she could have challenged it independently. If she did not, it is another matter.
Yes, ma'am. So it is set at rest. I came this.
Even in this appeal, whether that order needs to be implemented or not, because there is an interim order also working against him. That is why Mr. Das is becoming a little bit apprehensive.
I have absolutely no objection to the submission as it has been submitted by my lord senior matter. Only I wanted to bring to your lordship's notice with respect to the fate of the appeal as it has been presented by the opposite party, my lord, in this case before the appellate authority, that is under Annexure 3. There, after going through the appeal submitted by the opposite party number 3, opposite party, the issues were framed That is at page number 38, which has also not been disputed by the opposite party in this
38?
case, my lord. Because the appeal
Yes,
order
yes.
is in her favor. The questions, the issues were framed and the issues were answered. So my limited prayer before your lordship at this stage will be to once again, after giving the opportunity to all the parties, my lord, to once again decide these particular issues. Because that covers everything. My lord, what happened, my lord? There are 3 persons. Out of 3 persons, one is claiming that she was previously engaged as an Anganwadi helper. So that is why she requires a special treatment, my lord. The other second one person, my lord, she claims that she belongs to physically handicapped category, and accordingly, some marks extra marks are required to be added. 5% mark is required to be added in against her merit, my lord. The third person, who is actually meritorious in comparison to both of them. Now, my lord, in the meantime, because she, while ascertaining the position with respect to her, the appellate authority came to a conclusion that because in the meantime, she has already got an engagement in another Anganwadi center. So there were 3 persons in the selection list. So these points were actually, the issues were framed, and my lord, let these issues may be retained and a fresh decision may be taken at the level of the appellate authority. My limited submission with them. It is covering all the points.
No. Since an appeal was filed where you have also made the other person a party, natural justice demands that she has to be heard.
Your lordship may kindly appreciate one thing. First, regarding law, what my learned friend state counsel is saying, that is not permissible under law. An advertisement was published. Other day, I remember your lordship expressly said, mononoyana kora jai pariba. It's a selection, my lord. One clause is appended. My lord, once an application is there, my lord, advertisement is there, making others known what are the criteria, so that they would make the choice whether they would apply or not. My lord, advertisement is to be considered in toto, not to the exclusion of other clauses, my lord, not in isolation, my lord. Then there is no meaning in the advertisement. It was also considered by the authorities.
In any case, Mr. Das, when somebody is made a party in the appeal, he has a right of hearing. Whatever you may submit, whatever you are submitting, you may submit before the ADM. But if the opportunity of hearing has not been granted.
One thing your lordship may kindly appreciate. Suppose I will not have that annexure 2 pertaining to merit has been set at rest. If I have not approved this honorable court the second time, or the appeal would not have been filed, my lord, or appeal is withdrawn or dismissed, your lordship may kindly see what ultimately remains. Annexure 2 remains.
No, maybe.
So in this way, even if I withdraw the matter, or suppose I don't press my appeal there, your lordship in continuation of your lordship can direct for consideration, for implementation of annexure 2.
Why should I direct on his application?
No, it's my appeal. My appeal.
Your appeal, it is open to you to withdraw.
So if they are hard, that appeal, your lordship, ultimately, your lordship, other day also it was, I was canvassing, your lordship was, empty formality would be there.
No. This cannot be treated as
best possible defense. Your lordship may kindly examine. It is in continuation, such a rate proceeding.
No.
My lord, what if he would have been noticed? What would have been his possible defense?
No.
Because my writ application, pursuant to which the appeal is filed, only confining to implementation. Annexure 2 is in my favor.
So why did you make him a party? Why did you make her a party? You shouldn't have made her a party. Simply sought for implementation. And you didn't have to, you were not required to file an appeal.
If he has got anything to say regarding implementation, that he can say.
Whatever appeal you have filed, you will have to press your appeal, whatever grounds you have raised. And similarly, it is open to her. If she raises a ground which according to you is not tenable, then you can also object to it. It is for the ADM to take it.
appeal to cross appeal se file
cross appeal kare se to pari kari pari
independent appeal kari na mu writ re asili for implementation honorable high court
let us not
and ei je uta law re se claim karuchandi je thele se helper hisab re tangana mark add hobo, that is not permissible.
Then I will not say anything on that.
Mark out of
but you kindly observe one thing. My appeal is for the purpose of limitation of implementation of annexure 2.
All right.
And maybe that compass.
As directed, Sri S.N. Patnaik, learned AGA, has produced the original file of AWW appeal case number original case record of AWW appeal case number of 2015. Perusal of the order sheet of the appeal reveals that the same was filed on 12/3/2015, on which date notice was issued to both the appellant and respondents. Was filed locally. The appeal was taken up for consideration on 12/3/2015 for the first time, when the appellant and respondents were noticed to appear. On the next date, that is 23/2015, it was the CDPO Ulunda was directed to remain present and to submit documents. On the next date, that is 8/4/2015, it was observed that SR of notice is not back, for which fresh notice was directed to be issued to the respondent, fixing 23/4/2015 for hearing. Stop. On 23/4/2015 and thereafter, on 23/4/2015, there is no mention as to if the notice had been served on the respondent. Surprisingly, on the next date, that is 4/5/2015, the appeal was disposed of by passing the final order. It is evident that there is no proof of the notice having been served upon the respondent. Stop. This violates the principle audi alteram partem, and hence the impugned order cannot be sustained in the eye of law. Stop. Sri J.R. Das, learned counsel appearing for the appellant before the ADM, submits that the appeal had been filed by his client seeking implementation of the order dated 8/7/2011 passed by the sub-collector Birma Rajpur. Be that as it may, since the appellant had implemented the petitioner as a respondent, it is necessary to grant an opportunity to her before disposal of the appeal, which the ADM does not appear to have done. For the foregoing reason, therefore, the writ application is allowed. The impugned order under annexure 3 is hereby set aside. The matter is remanded to the ADM Suvarnapur to rehear AWW case number 2/2015 afresh, after granting opportunity of hearing to all concerned. Stop. This being a case of the year 2015, the ADM shall do well to try and dispose of the same as early as possible, preferably within a period of 2 months.
One thing, my lordship kindly appreciate. With the certified copies, we would instruct our client to appear, your lordship, fix up a date.
For convenience,
delay can be cut short.
For convenience, the parties are directed to appear before the ADM with a certified copy of this order on what date? This date
15 दिन पर को any date election 15-20 दिन पर हो से आगे appear करिवे तेनु चलिबो सेटा 15 दिन पर any date your lordship I would instruct just after 15 days.
आज 29 नहीं So May 15th,
Okay.
on 15th May, on which date the ADM shall fix a date of hearing of the appeal.
Appeal ଟା ତ ଗୋଟେ କି ଦିଟା date ରେ ସରିଯିବ subject ର।
Yes.
ଏଇଟା I bow down your lordship because sometimes also I am this side that.
No, no.
It's a matter of record of light man.
That you are too experienced to know.
Item 17, your lordship. The petition is for transfer of CP number 61 of 2022 filed for divorce from the Learned Family Court Cuttack to Learned Family Court Jajpur, your lordship.
You are appearing for the other side?
Yes, your lordship, I'm appearing for the opposite party, number 2, the wife. And my lord, we don't have any objection if the matter is being transferred to Jajpur because the opposite party, number 2, is presently staying at Jajpur itself, my lord.
All right, very good. The husband of the opposite party has filed this application seeking transfer of CP number 61 of 2022 from the court of Learned Judge Family Court, Cuttack, to the court of Learned Judge Family Court, Jajpur, comma, filed by, who filed this case?
Husband,
husband, your
petition.
Filed by him. Why did you want this transfer?
Because there are other proceedings pending.
It is submitted that the transfer is sought on the ground of pendency of several other proceedings between the parties at Jajpur. Stop. Your good name?
Jemima Sarkar.
Jemima?
Sarkar.
Miss Jemima Sarkar, Learned Counsel appearing for the opposite party wife, submits on instructions that her client has no objection to the case being transferred as sought for. In such view of the matter, mainly on the ground that it would also be convenient for her, convenient to her. Stop. Considering the submissions as above, and since the opposite party wife has no objection to the prayer for transfer, comma, the same is allowed. It is directed that the proceedings in CP number so and so pending in such and such court shall be transferred to such and such court. Stop. Seat of records. Learned Judge Family Court, Jajpur, shall issue notice to the parties for their appearance and proceed thereafter in accordance with law.
Much
Bless your lordship.
Item 18.
Item 18, as per direction, it has been complied with. The sub-collector was directed to make an inquiry. He has already made an inquiry. The report has also come.
Item 18 is a transfer matter, Mr. Das.
Item 18.
No, it is contempt matter.
Item 18. Oh, sorry. I'm so sorry. कौन हिची?
The direction was
Complaint हिची?
at page 10. Yes.
Hey, affidavit कहीं?
Affidavit, if your lordship directs, I can file. If your lordship wants.
File. कर दे ले recorder होजी है यार खाली वो. Complaint हिची?
Sir.
Complaint हिची? हाँ? Copy कौन? Copy कौन? ଆପଣ କମ୍ପ୍ଲେନ୍ ହେବା ଦରକାର ନା କପି ନେଇ କଣ କରିବି? କଣ ଏଇଟା କଣ ଡାଇରେକ୍ସନ କଣ ଥିଲା?
Direction ହେଲା to dispose the appeal opportunity of hearing to petitioner to all concerned preferably within this court as opposed by not sub collector
complaint petition has been disposed of कौन?
complaint petition of the petitioner.
Opportunity was also given.
नहीं कंप्लेंट କଥା ତ କୋଉଠି ଡିସାଇଡ୍ ହେଲା କଥା କହିଲେନି ଦେଖିଲେ
Concluding paragraph is at least.
Since the CDPO is the chairman, the chairman for the selection of Anganwadi helper of the
Helper.
Begunia has not committed any irregularity, illegality in the selection of the OP number 5. That is not
what
proper.
he has found.
Huh?
That is what the sub-collector found.
Where is the disposal of the complaint? That was the direction. He has to dispose it of either way, rejecting it, allowing it, whatever. ସେଇଟା ଦେଖନ୍ତୁ ଏଇଟା ହେଇନି comply ହେଇନି. He has justified the original action. ଯେ କାହିଁକି ମୁଁ action ଟା ନେଇଥିଲି. Learned Sri A.R. Das, Learned AG submits that he has received some instructions, but requires further instructions from his from the sub-collector, and therefore requests for some time. Raise this matter on 13th May. से दिखता हो कितना सीट कल देखी दो इधर
Item 19.
19 what
So the postal endorsement has come, my lord. It says that addressee left without instruction. So return to sender, my lord. Lordship may kind of glance at this transfer case, my lord.
Since notice has returned unserved with the endorsement that the addressee has left, let a fresh copy, let an extra copy of the transfer application be served upon Land State Council, who shall cause the notice to be served upon the opposite party through the IAC of the concerned police station, indicating that the matter shall be disposed of. Matter shall be taken up for hearing on 20th May. List this matter on 20th May.
Item not 20, between the similar parties, my lords.
Same order.
My lords, may I pray one thing, my lords? Let both the matters be tagged up together.
No, I said this.
Much obliged.
Item 19 and 20 may I pray for free copy of the order.
Free copy of this order be handed over to Learned AGA for compliance.
Item 21.
21 with same order.
The 21, I'll take a press notice and correct address.
My lord, I am entering appearance.
He is appearing?
I'm already entering appearance.
Sri Rajit Roy, advocate and associates have entered appearance for the opposite party by filing wakalatnama. Same be kept on record. Their names to be reflected in the cause list.
My lord, they're seeking it for the transfer from the Bhubaneswar, Family Court 1 Bhubaneswar.
Consider it some other time.
As your lordship, please.
Take time.
My lord, may I pray for a copy?
Leave this matter next week.
My lord, may I pray for a copy?
1 week after.
notice होइचिंते कॉपी कर पाइ नथिबे अपन.
My lord, हमको इंटिमेट करले कि सेटा आसे सेठी रहू नांती बट समय सुनलु कि स्टे अछि ऑर्डर टा हाई कोर्ट वेबसाइट टू सो आई एम प्रेइंग फॉर अ कॉपी.
Give a copy. Mr. Lanka, you give a copy of a private arrangement. Why should I?
I'm grateful.
Item 22. No counsel.
Continue.
It's about to continue.
1 week after next week.
13th May.
My lord, 22, my lord, have a glance to last order, 15/4, my lord. The notice already served, my lord. And my lord, the notice delivered on 3/4/2024. However, there is no appearance to given another opportunity. The matter was fixed for today, my lord.
How Novatal Ajio? Let me come, I'll take it up after recess.
My lord, may I be pardoned. My lord, your lordship would recollect that 72-year-old man content matter. Your lordship had specifically fixed the matter to last Friday. My lord, I've been following up with the registry, but for some reason or the other, they're not listing the matter and asking me to unnecessarily disturb your lordships, my lord. My lord,
This lordship will not be disturbed so easily.
I'm so grateful, my lord. My lord,
Very difficult to disturb this lordship.
I'm grateful, your lordship. My lord, my kindly, if her direction may be.
Please go. On what ground do you want transfer?
My lord, other several litigations are pending at Balance. 125 DBM's case and 498A.
All right. The petitioner wife seeks transfer of mat suit number 40 of 2023 from the Court of Learned Civil Judge Senior Division Uddola to the Court of Learned Judge Family Court Baleshwar. Filed by her husband opposite party. Be it noted that notice of the transfer application was served as evident from the postal tracking report on 3/4/2024. There was no appearance on 15/4/2024, for which the matter has been adjourned to today to grant an opportunity to the opposite party to appear. There is, however, no appearance. As such, without waiting any further, and in view of the valid service of notice, the transfer application is taken up for hearing. The petitioner seeks transfer of the aforementioned case to Baleswar on the ground that two other petitions being filed by her, one being under section 125 of CRPC, that is CRP number 145 of 2022. कौन लिख ले? And the other being DV Miss case number 76 of 2022 are respectively pending before the Judge Family Court Baleswar and Learned SDGM Baleswar. It is therefore contended that it would be convenient if the proceeding under section 13 filed by the husband is also transferred to Baleswar. After considering the submissions and the pleadings, which have gone unchallenged, this court finds no reason to refuse the prayer for transfer. The transfer application is allowed. It is directed that the proceedings in MAT suit number 40 of 2023, pending in the Court of Learned, Civil Judge Senior Division Udola, shall be transferred to the Court of Learned Judge, Family Court Baleswar, for disposal in accordance with law. Stop. The Learned Judge, Family Court Baleswar, shall, upon receipt of records, issue notice of appearance to both parties and proceed thereafter. Yes.
Item 23.
Granted interim bill to period of 2 weeks, my lord.
Yes.
Petitioner has surrendered.
When counsel to the petitioner files surrender certified copy of the surrender certificate in court indicating that the petitioner has surrendered to custody on 6/4/2024 after expiry of the period of interim bill.
Paper next week.
List this matter 1 week after vacation पर आसु. एबे जाइछि कोन? कोन? एबे जाइछि कोन vacation? आगे?
Next 1 week after.
1 week after मन जहा हो. Yes.
Item 24. File an IA for extension of time of surrender in respect of petitioner number 5 and 7, manner.
Why?
During manner corona time, he could not able to.
Yes.
Could not able to surrender before the Learned Court below, my lord.
This is surrender and release.
Yes, my lord. Order dated 11.
Considering the submissions, therefore, 2 weeks further time is allowed to petitioner number 5 and 7.
Yes, ma'am.
To surrender in terms of the order dated 11/10/2023.
One father's name Kasinath Das. Maybe cost title may be permitted.
Land council petition is permitted to correct the typographical error in the cost title.
23 ମସିହାରେ କରୋନା
नहीं कोरोना ହେଇଥିବ ଆପଣ ଦେଖୁନା ଜଣେ ଜଣେ ମାସ୍କ ପିନ୍ଧି ବୁଲୁଛନ୍ତି ବର୍ତ୍ତମାନ.
In item 25 Millards is an application for extension of the bail order Millards on the ground that the petitioner was unwell and was on complete bed rest, therefore was unable.
This is the first time you are praying for time.
Yes, my lords. The time, my lords, I'm asking for an
Extension for
Yes,
the
my
first time.
Yes, my lords.
All right, 2 weeks time.
Grateful, my lords.
Item 26.
May I please?
What modification?
That police was not inclined to grant bail to the petitioner. Our direction was given to be surrender with court bail, move for bail, or what of first or second order there, my lord.
Yes.
And even the charge sheet has already been filed, my lord, that I have annexed my lord 3 as page 18, my lord.
Yes.
D07, 294, 506, 323, 225, my lord. Look at the injury report I have given. It is that.
How can I modify it?
But Lordship has told that you filed a miscase, so can I recall the order? That's a miscase filed, my lord.
I
I filed an anticipatory bail application.
He has filed another anticipatory bail.
Okay.
It was not inclined.
Earlier it was disposed of. So he
What
now he has
modification?
filed an interim application that the injury report, my lord, can see page 27. That is
Fracture of
grievous in nature and a fracture and dislocation of lower
third of right leg.
right leg.
So 307 is not met out in view of the injury report submitted by the ION. Maybe case of 325, right? The petitioner is working an employee, at Bhubaneswari Mines Limited at Annex 5, page 28.
Therefore, modification of the order is made on the ground that in the meantime, charge sheet has been submitted and the injury report reveals that the injured had sustained injuries on his limbs, which are not vital parts of the body. So, as such, the offence under section 307 is not made out. Under such circumstances, this court is inclined to allow the prefer modification. The following paragraph be substituted in place of paragraph 5. You were considering submissions, surrender release. Surrender release, yes.
Item 27.
2 weeks,
2 weeks for that.
Yes, my lord, extension of time.
First time?
No, my lord, there was a order 27 February. There is a correction in the court cause title 27/2/2024 order. ABL appeal 14264 of 2023.
So already you have been granted 2 weeks time. All right, 2 weeks further time is allowed.
Published.
Item 28.
May I please? My lord, extension of time, my lord. The first time, my lord, directed surrender and go on bail in the period of 2 weeks. But meantime, my lord, petition number 1, 7, 9, and 10 arrested a religion bail by the POCSO court, my lord. The meantime, 12 POCSO added, materially transferred to additional session judge from special court under POCSO Act Navarampu. In TR case number 7/2000.
Will say in court in session over the matter?
Again.
Only that modification you want?
Extension of time.
All right. You, instead of the word court below occurring in paragraph 5, the words court having session over the matter.
TR case number 7/2024.
ये तरह पूरा मॉडिफाई करे पूरा है ना उमर कोर्ट पीएस केस नंबर 333 corresponding to GR case टा जाके instead of GR case number 541 of 2023 the words TR case number 7/2024 7 of 2024 be inserted and in place of learned JFC उमर कोर्ट कौन लिखा है वो?
Additional session judge कम special court under POCSO Act Navarampu.
कोई जगह?
Okay?
कोई जगह?
Navarampu.
नवरंगपुर भी added है ना?
Additional session judge कम
ठीक है,
special
ठीक है,
judge
ठीक है.
POCSO Act.
2 weeks for the time is allowed to.
Item 29.
May I please, lords?
This petition is a juvenile.
Yes.
May I pardon your lordship? I have to verify whether the co-accused has been released on bail.
on similar footing or not, just now I have
This is
received the-
separate thing. I am a juvenile, my bail is to consider. I have given for replacement, there is adult co-sponsor religion bail. But so far my juvenile is concerned, I have a different consideration. My conscience is not depending upon the
Passover, I
co-sponsor.
apply for Passover tomorrow or day after tomorrow. I will verify whether he is on similar footing or not.
Well, if he wants time to, till tomorrow also. Let it come to, let this matter tomorrow.
Time, my lord. So tomorrow it should be last.
Tomorrow.
I could also the order sheet they have taken how many times for purposes CD.
Anya court re
Let this matter tomorrow as prayed for by 11th State Council. All right.
eighty first time.
We will list item number 1. The lawsuit may be permitted to withdraw.
Permitted to withdraw.
With the liberty to file better application and take instruction regarding the stage of the trial. File the better application with liberty to file better
With
application.
liberty to file better application. Yes, that's all.
Obliged.
Item number 2.
May I please be for a
My lord, petition of custody since had made 21 minutes. 302 and 30. Most of the.
When to produce the depositions of the.
Already, my lord, filed.
Were filed?
My lord.
This. कहीं तो कोर्ट नहीं माने आम
BLFL 103 ने अछि 103 रे
ता संगे आसीची
कनेक्टेड मैटर रे
103
अछि 9136 रे राजकिशोर दास हां राजकिशोर दास
the depositions are in the other bail application.
already.
What is the I mean, what is the allegation?
My lord, my lord directed to renew his prayer for bail after examination of eyewitness namely Subhendu
Where is that order? Where is that order?
and Ranjit Kumar Lenka. Ranjit Lenka dead, my lord. Subhendu Kanta Das has PW10, my lord, already been examined by the order dated 30.
Where is the previous order? Let us see the previous order.
BLFL
So, the petitioner to renew his prayer for bail after examination of the material witnesses, including eyewitnesses in the case.
My
Is the order. But no name was given.
Yes, my lord, already 5353.
No. I did not say anybody's name in my order.
That order certified copy of the Xerox copy.
Sir, kete 9138?
No, 5353 of 22.
5353 of 2000.
Report of dated, my lord, 13/10/22.
देखिए
Plus.
No, I have not named any person, any witness. I have not named any witness. अच्छा, ये Subhendu Kanta Das and Ranjit Kumar Lenka.
Right.
Let us see
Ranjit Kumar Lenka died.
Yeah.
Subhendu Kanta Das turned hostile. Sukant Kumar Raut, PW11. He also turned hostile. But my lord can see PW1 and 3. Only police witnesses have.
No.
My lord, 3 years in custody, my lord. Only
PW1 is enough.
Police personnel are only. So one is my lord, the informant of the case is not the eyewitness. Other eyewitness are turned hostile, my lordship. and the present
The
petitioner
first
is
circumstance is he died in the premises of the accused persons. He died in a suspicious manner. It was not a natural death. The immediate post occurrence witness is PW1, who has seen the dead body lying in the roof, which is not a place to die. So these are all circumstances against you.
PW3 also, my lord, stated similar.
And you have not given any explanation. I remember this case.
my lord, in Chiku alias Umakanta Swai, he is a drug addiction patient and he is thereafter, my lord, he is
No, Mr. Mahathi,
accused-
I am not convinced.
two accused persons. Your lordship, one Chiku is, my lord, he is the assistant of the and Rajkishore Das is the owner of the de-addiction center. There, the remaining 3 years in custody, your lordship. Only I pray, my lord, for the some period, your lordship, only 4 police personnel are IO and other
No,
witnesses are
No,
there.
I am not convinced at all. I am not convinced at all. No.
3 years already custody, your lordship.
The petitioner,
My lord, one accused person, your lordship, consider in the Chiku alias Umakanta Swai. He is the servant of that de-addiction center. He is not the owner. Raja alias Rajkishore Das is the owner of the de-addiction center.
no, he may have been directly involved. How do you know? How do you know?
None of the witnesses against stated against the Chiku alias Umakanta Swai.
Well, I'll consider his Chiku's case for some period. Yes. The petitioner's earlier application for bail was rejected by this court, granting him liberty to renew his prayer after examination of some material witnesses, including eyewitnesses in the case. The present application has been filed, as in the meantime, several witnesses, including eyewitnesses, have been examined. It is submitted that one of the main eyewitnesses cited by the prosecution, that is PW10, has turned hostile. There is no other witness has stated anything against the petitioner. Stop. This court finds that though PW10 has turned hostile, yet PW1 and 3, the testimony of PW1 and 3 cannot be brushed aside lightly. It is submitted that the petitioner has been in custody for nearly 3 years, and he was only an employee in the de-addiction center. Taking into consideration all the above facts, particularly the fact that the material witnesses have all been examined, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months. Aratare, ଦେଖନ୍ତୁ ଆରଟା ଇଏ ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆସିଛି ନା ଆରଟା ଆସିଥିଲା ଆଗରୁ?
ଆଗରୁ ଆସିଥିଲା। Permitted to withdraw.
Permitted to withdraw.
Item number 3.
Lordship, we have taken out the passport for the day.
Passport.
Item number 4.
Permitted to withdraw. Permitted to withdraw.
Item number 5.
Item number 5 already acquitted, my lord, permitted to withdraw. Trial completed.
Permitted to withdraw?
My lord.
All right, permitted to withdraw.
Item number 6.
Your lordship. The figure 6, figure 2, 35 is there, lord. The accused in custody
since 18/2021 allegation due to their land dispute, admittedly tussle is there between both parties. The allegation of the informant was that the other of the
Have the eyewitnesses been examined?
yes, yes,
Give the depositions.
no, sir, I have given the original copy last time. But
दीजिए देख रहे हैं मेरा एप्लीकेशन फाइल लेते हैं
original copy date.
नहीं डिपोजिशन रख लो
Statement of the informant given.
It's not there in the file.
Later we pass over, you may supply that copy.
I'll give Xerox.
Pass over, sir.
Yes, one pass. Just give.
No 7. Also one password.
Password one password नहीं password तो
You'll also scenario is another code.
password तो देखिए
One password.
one password ही तेरी होने क्या password yes.
Item number 8.
Item 8, your lordships had called for a status report. Well, it's already 2.5 years he's behind bars. He is the driver of a vehicle which was caught in an NDPS case, my lords. Here, my lords, the main accused, she is already the owner of the vehicle, has already been.
No
released.
conscious possession, honor of vehicle. The present petitioner is conscious possession and petitioner is outsider also.
And your lordships, the charge sheet also reveals that he was getting 10,000 per trip. That is all.
No, the problem is he's an outsider.
Well, that is true. But
I don't grant a bail to outsider.
Well, it's 2.5 years he's been.
No.
And only one witness has come.
As directed, the court below has submitted a report stating that out of 6 witnesses, only 1 has been examined so far. That's it.
As your lordship, please.
No question of interim. I will not grant it.
साक्षी भी चलने तो
Oh, I know.
Your lordships may keep it after another.
I'm just keeping it pending.
Pending one. Yes.
Let this matter 1 week after.
Not 1 week because
1 week after it will not come.
vacation पर
vacation for us.
This matter after vacation.
If
The problem is, in some cases, I have granted interim bail.
आसुनन
Yes.
No, that is true, my lords. Assume.
So the case gets stalled forever. At least here, the case will be disposed of. The trial will at least conclude. Maybe a bit delayed, but it will always happen. But without the accused, that will be a big problem. The huge number of NBWs that are pending now, because of these absconding outsiders, that is a problem.
Even one of my cases, I know because he got interim bail from this honorable court. Not your lordships, but some other, and thereafter he didn't turn up.
So that's a big problem. He will never turn up. Why should he turn up? Why should he turn up? Once he gets released, he thinks it's acquittal. It will be almost akin to acquittal. Anyway, this is matter after vacation.
After vacation. Oblige.
Item 9, my lord, he is in custody since 17/9/2021. Earlier, there was a direction to renew the prayer for bail after examination of the victim. This victim has been examined.
Supported. Victim 376(3) ଅଛି notice ଯାଇଛି.
Notice was served to the wife of the informant on 19/3/24.
Then State Council submits that notice on the victim has been served on
notice to the wife of the informant. Because informant was absent, therefore wife has received
Has
the.
been served
That is on 19/3.
on the informant on 19/3/2024. Consensual is all right, but the problem is you video viral.
Viral. His custody since 17/9. I don't know, grant him some period of it.
All right. The earlier bail application of the petitioner was disposed of, granting him liberty to renew his prayer after examination of the victim. So the victim has been examined in the meantime as PW2. Learned counsel for the petitioner furnishes copy of the deposition of the victim. Stop. After going through the deposition of the victim and the nature of accusations, though not inclined to grant a regular bail to the petitioner, looking at the period of his detention, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 3 months.
Not there.
Petitioner is a lady, custody since 14/8/2021, my lord.
Last
Out
package
of-
also directed to file the deposition copy of the
Yes, sir.
12 witnesses.
Deposition. Who are the main witnesses?
Informant,
Yeah.
son
The
and daughter.
informant not examined and son has been examined. There is no specific allegation so far as the petitioner is concerned. And your lordship kindly peruse PW1.
Bikram Narendra Singh, Duli Pradhan.
Yes.
And 20 other members came to us, abused my father, searching Melasi Kodagale, my father and towards body. The above named accused persons chased my father, holding Katti, Bhujali, etc. I myself, my mother, and yes. Tapre, okay. Okay.
How others are not supporting.
Doctor and informant.
They have not been examined. My
Let
lord.
they be examined.
Since chemical examination was not obtained, my lord, trial has been stalled. So, lordship call for a report since 14/8/21, my lord.
Trial has stalled.
Yes, my lord. So, lordship call for a report.
Learned counsel for the petitioner submits that the trial has been stalled for want of chemical examination report. So, the court below is directed to submit a report in this regard at the earliest. Please this matter vacation for root date.
Commencing 13th May, sir.
13th May. We commencing 13th May. This order be communicated to the court below forthwith. The problem is the problem is no, not always that the court below is not aware of it or the court below. If the chemical examination, because the SFSL is understaffed, thoroughly understaffed. So they are finding it difficult. They are getting reports, they are getting requisitions from all over the state. They are thoroughly underprepared to do it.
There is a shortage of manpower.
That is what I am saying, understaffed. Yes, item 11. Yes. ଆପଣ ଇଡିଥିଲେ ହଠାତ୍ ପୁଣି ଭୁବନେଶ୍ୱର ପଳେଇଲେଣି ଭଲ 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 କିଛି ଅସୁବିଧା ନାହିଁ more the merrier. Yes. What is this, Mr. Mahapatra?
Petitioner is on custody, my lord, since 22/9/2021. The offences are in lordship's
Govinda Sahu.
and he moved along with other accused persons, my lord, in BLAPL number 10107 of 21. Other co-accused persons have been released on bail, but whenever the petitioner is concerned, my liberty is given to renew the prayer.
Where is that order?
Examination of
In BLAPL?
BLAPL number 10107 of 2021.
Liberty to kichhi nahi?
Yes, your lordship.
Oh, after examination of Vijay Kumar Sahu. So Vijay Kumar Sahu, Darjang Dam of Village Monthly, Torani Sahu, Chabi Sahu.
But Vijay Kumar Swamy Junior is there, man, the jealous copy of the certificate.
Yes, yes, I'm reading it. You are Govinda Sahu.
My lord. It is omnibus in nature, but it appears.
Tarani Sahu. Govinda Sahu.
Name is, he has named the present petitioner, but it is omnibus in nature.
Who has been released on bail?
Must be released on bail, your lordships. The three women.
Only the ladies have been released. Let us see your cross-examination. You have not cross-examined? Mr. Babat, you have not cross-examined? You see, after paragraph 7, it says cross-examination by learned defense counsel for the accused persons will be Jitendra Sahu, Jitendra Vishwanan, and Vibhuti Sahu. You have not cross-examined.
Yes, yes. But fact remains that man, it is omnibus in nature. Whenever
What omnibus? No, not omnibus. In the case of murder, what are you saying omnibus? So, pura clearly na ଦେଇଛନ୍ତି ଆଉ।
ସେମାନେ ଥିଲେ କିଏ କେମିତି assault କରିଛି କହିନାହାନ୍ତି।
ନାଇଁ ସିଏ ଆଉ କହିବା କଣ ଦରକାର? ଯିଏ ଜଣେ ମನುଷ୍ୟକୁ ମାରୁଥିବ ସେ କଣ ସବୁ ଡିଟେଲ ଗୁଡା କହିବେ? I went towards Darjang Dam and found the accused persons, namely so and so, including you and two other ladies. They were assaulting my brother-in-law, namely Jagan Senapati, by means of Thenga, Badi, Bhujali, and Khonda. What is the postmortem report? What is the external injury? I remember this is an Hon'Ble case.
My lord, honorable case. But the mother, actually, in fact, what has happened was the mother has expired 1 year back. The petitioner could not attend that Sudhikriya. Now, 1st May is the first death anniversary.
ସେଇଟା କୋଉଠି ଆପଣ ଗୋଟେ ଆଇଏ ଫାଇଲ କଲେନି?
କେହି ତ ତାଙ୍କର ନାହାନ୍ତି ଆଉ ଆସିବ କି ଅଛି ଖାଲି ଫୋନ କରିକି ଜେଲ ସେ କହୁଥିଲା।
Yes.
But the CD was not called for. From the very beginning, he has prayed for to file the deposition.
No.
Direct allegation from the
earlier application of the petitioner for bail was rejected, granting him liberty to renew his prayer.
ଆଗରୁ ଆଜ୍ଞା ବେଲ ଯାଇଥିଲେ ମମତା ସାହୁ ଆଉ
after examination of Vijay Kumar Sahu. In the meantime, said Vijay Kumar Sahu has been examined. As PW8, learned counsel for the petitioner furnishes copy of the deposition of Vijay Kumar Sahu. Perusal of the deposition reveals that said witness has named the petitioner as being one of the assailants. So it is submitted that the allegations are omnibus in nature, in as much as what specific role was played by the petitioner has not been stated. Stop. Be that as it may, having regard to the statement of evidence of PW8 and the nature of accusations, while not being inclined to grant regular bail to the petitioner, taking note, however, of the submission that the first death anniversary of the petitioner's mother is falling on 1st May, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 3 weeks.
1 month, your lordship.
ଯାହା ପାଇଲେ ଆଉ
Highly obliged. Highly obliged.
ବାନ୍ଧୁ ଥା
ମାସେ କରିଦେଲେ ମାସେ।
ନା ମୁଁ 2 ସପ୍ତାହ କରିଦେଲି ମୋ ପାଟକୁ କେମିତି
deeply obliged, lord.
Item 12.
Lordship kindly permitted to withdraw.
Deeply obliged.
13.
Custody more than lady custody more than.
Juna bhoi.
I have filed an.
Juna bhoi. Juna bhoi ta
interim
reject
bail
kiya. Ini
more than two in exam. Of the my lord, husband of the person undergone neurological surgery.
Okay.
So I am
You file an IA?
IA file.
Let him take instruction then. You file serve a copy
I have served.
along with the documents.
Yes, ma'am.
Very good. The Land State Council shall take instructions with regard to the amendments made in the IA, including the documents enclosed there. List this matter in the week commencing. Sixth May January.
So, 21 ମସିହାର
Neurological surgery.
and he is the Juna boy is the principal.
No. Sarnista.
He is also accompanied with that.
No,
That the murder case.
No, no, no. 8/1/2024 में document है.
I am
8/27/10.
and the dial. So Sarnista, my lord.
I have already rejected your bail application on merit.
That is in the year 2022. That is on my lord.
So what is the change in circumstance? There is no change in circumstance. Anyway, you take instruction.
Trial is now going on.
Out of 69.
You take instruction with regard to the IA.
More than
Then
2
I'll
years, I
consider.
prefer interim bail because more than 2 years in lady.
So when do you work? When can you obtain the instruction? We commencing 13th May.
Right.
Yes.
Item 14. May I please, Your Lordship? The petitioner is in custody since 29/2021. My lord, it's a case under section 302 along with other offences, my lord. Kindly have a glance to the running page 12, the earlier order, my lord. My lord has given liberty to remove.
Bhaino Das, Ranjan Das and Sunita Das.
Yes, my lord, I am supplying the copy.
Examine ହେଇଯାଇଛନ୍ତି.
Again, these.
No, Bhaino Das and Ranjan Das was examined. They were found hostile. Though the Sunita Das was examined or not. That for that reason it was kept.
Sunita Das ଦେଇଛନ୍ତି?
No, Sunita Das ଦେଇନି. Again, time and again, someone was issued to the.
Sunita Das 161 देखिए.
She did not turn up.
Sunita କଣ ଅଛି?
And as for the day beginning, he has praised before the court that to file the deposition copy of Sunita Das. That the order dated 10/1/2024.
I order ସେଟା ବି file କରିଛି. Another.
Will obtain a report from the court below. Why Sunita Das or whether Sunita Das has been examined or
Examined or
not?
not, if examined.
Not examined. I have supplied a copy. The order copy, my lord.
No, this order was passed on 29/11/2023. Sorry, 9/2/2024. In the meantime, she may have been examined. How do you know? The court below is directed to submit a report as to if witness Sunita Das has been examined as witness in the trial. Raise this matter in the week commencing 13th May. No.
Item 15.
Pass over to Friday.
All right, not Friday. Thursday, the Wednesday day. Thursday and Friday, second appearance.
Published.
I don't know. So either you do it tomorrow or day after tomorrow.
Day after.
Day after tomorrow, yes. Day after tomorrow, other list may have been exhausted, then you can.
Deposition order, my lord. Published.
No. Item 16.
Item 16.
May I be permitted in VC mode, my lord?
Yes.
My lord, may kindly see the last order passed by your lordship. My lord had called for report.
Regarding the status of trial.
Yes.
No, that is received status report.
Status report has not been received. Status report is not received. Remind the court below to submit the status report as directed within by email forthwith. List this matter in the week commencing next week. 6th May. This order be communicated to the court below by tomorrow forthwith. Tomorrow. Yes.
Item 17.
May I please back? Madam, last occasion your lordship has directed the state to obtain the health report of the medical health. Madam, I filed this IA. Earlier your lordship allowed 4 months interim bail in BLPL number 12/2/45/23. Petitioner surrendered in time, my lord. Petitioner only son is disabled and mother is serious, my lord. On that ground, your lordship has asked for the report.
Mother is a paralysis patient, my. But he has obtained that prescription from a pharmacist, not from the doctor. My lord, from the physical verification, the IO, my lord, this is the report.
My lord, sincere, but last occasion, your lordship grant me 4 months time. I surrendered. Let me go through that report. If what he says is correct, then you will have to withdraw the IA. My mother is serious, my lord. That is a fact. Prescription on verification of prescription, it was found that the prescription was prescribed by pharmacist Akshay Kumar Sahu of PHC in Machogan. On asking, he stated that he prescribed the prescription without examining the patient. One relative of patient came to PHC in behalf of patient, and on his request, I prescribed. That is good. My lord, why are you getting into all these things? The question is, they may have given you a wrong surrender करची time. My lord, at least ताको 2 मास समय दियंतु से ता मारो बाप माने ता पुरो कर देगी छाड़ दियंतु my lord. Mr. Mishra, I am giving you an opportunity to withdraw the IA. Obliged, man. I am withdrawing. Please, permitted to withdraw.
Item 18.
My lord. Yes, my lord. Contribute to issue the NDPS Act, my lord. Here, my the petitioners in custody 3422, my lord. And there is, my lord, 2 bolero, my lord. First bowler is 3 person, 2 bag, my lord. And second bowler is 1 person, 3 bag, my lord. Petitioner is a driver and first bowler, my lord. And contraband one.
Is there my 68 kg ganja in both the vehicles. It was 170 kg.
170.
And he was apprehended from the spot.
In one vehicle,
one vehicle, two
One
bag,
vehicle,
my lord.
2 bags, there's 68 kg.
68.
Another vehicle, 3 bags, 102 kg.
Petitioner is first bag. First bowler ru
ସେଥିରେ ବି ତ ଗଞ୍ଜେଇ ଥିଲା ନା
ସେଥିରେ 60
ଦିଟା bag ଥିଲା.
ଗଞ୍ଜେଇ ଥିଲା
2 ବର୍ଷ ହେଲାଣି. 20 out of 22%, 3% again.
The petitioner is in custody since
3/4/22, my lord.
3/4/2022 in connection with such and such case. It is submitted that the 68 kgs of ganja. No, kete petitioner gade thile seta kete?
68 kg.
68 kgs of contraband ganja were recovered from the vehicle of which the petitioner was the driver.
My lord.
It is submitted that the case has been fostered falsely. And in any case, the statutory formalities were not complied with. Sri Mahuto Learned Counsel appearing for the petitioner further submits that trial
3%, my lord.
Total witnesses?
21, my lord.
Only 3 out of 21 witnesses have been examined so far. And in the meantime, the petitioner has spent more than 2 years in custody, which affects his right to speedy trial, guaranteed under Article 21 of the Constitution of India. Having regard to the submissions as above, and looking at the delay in conclusion of trial, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 4 months.
Item 19.
May I please, Your Lordship? My lord, the petitioner is in custody since 14th January 2024. And allegation against the present petition that 120B, 384, 420, 34 of the Indian Penal Code. In between, my lord, the principal accused Tripati Khilo released on interim so bail in ABNPL 1962 of 2022, my lord.
I think one
Hogdar 7923.
Hogdar also released on bail.
So he stands on the same footing? Same order.
Obliged also.
I don't know, 20.
My lord, your lordship, last week occasion granted interim bails for 2 months, my lords. Then
charge sheet submitted 376 2L and 3 SCST. Notice will for my lord, can see the PW1 who stated that the informant is dead.
The victim is the daughter, so victim को जीवन
PW2 notice may be served.
Yes.
My lord, sir, the victim is two each already married with us.
No, the notice has to be issued before I can hear this bail
Your
application.
lordship, last occasion,
First time as the last.
last occasion, your lordship granted bail. And I.
That is history.
Out
Mr.
of
Dang.
the, out of the courtroom, my lords.
Mr. Dang, that is history. And history doesn't always repeat itself. History repeats itself sometimes, but not always.
My lords, first order, my lords.
Let an extra copy of the bail application be served upon the State Council, who shall cause the same to be served upon the victim through the IIC of the concerned police station, indicating that the matter shall be taken up for hearing on in the week commencing 13th May.
13th में तापर कहने से कौन बाहर ही जाइए पुणे
Conjugal right effect हो
20th May.
চেষ্টা করলে তা ঘরের চেষ্টা করেছি
ଆଜ୍ଞା ସେ ପୋଲିସ ଖୋଜିବେନି ଆପଣ କେମିତି ଶୁଣୁଛନ୍ତି ଆପଣ କପି ଦିଅନ୍ତୁ
ହଁ ମ୍ୟାଡାମ
Item 21.
This is 2024 right up the 2000 Sahu.
Miller,
Yes,
may I please?
yes, please.
This is a case under section 20B2C. He is in custody since 29/9/2021.
I have already granted him interim bail twice.
I'm coming to it.
Twice can you see?
I'm coming to it. He is in custody since 31 months. Running 32 months is doing well. Out of 16 charge sheeted witnesses, only one witness has been examined till now. He is a local person, quantity is 1 quintal, my lord, 100 kilo. Coming to it, my lord. My lord has rejected an application. I'm not stating anything, my lord. I have given the documents, my lord may see, and only on the leniency ground only I can pray for that, my lord. I given the valid points in that judgment. Apex culture. Kindly have a glance to the quantity as well as the period of detention, and he is an outsider. My lord, I'm not coming to it, my lord. Only for the sake of information, I'm giving it, my lord. I'm not now, right now in this case, my lord. Absolutely, I'm out of this case. It was only my lord's court of it. Recently, it has been passed in the month of March. From before and only, I have said that, my lord, I have prayed that on the ground of leniency, I can pray, my lord.
No. Here, what has happened
I'm
is.
not going to the merits of the case because I know if
Please hear my submissions.
My lord.
I've been hearing your submissions patiently. There are 3 bail applications you filed. The first application was rejected on 10/5/2022. Then I granted you interim bail for a period of, let us say, 3 months on 11/11/2022. Again,
after
on 13/10/2023, I granted you 2 months.
My lord.
So this is the last one.
My lord, kindly have. No, my lord, he is a local person.
No,
he is a local person.
Already I have granted you interim bail twice.
My lord, he has surrendered twice also.
No, it's not.
He has surrendered.
He has to surrender.
Because no, my lord. Because this court was having a belief that whoever goes, they never.
No,
only I can say that, my lord, he has surrendered.
Sure, not whoever goes. That comment is in respect of outsiders.
My lord, I'm stating that he's a localite.
I want to show that comment. So you must be very, very careful in the choice of your words. When you said that it is almost an aspersion on the court. When you said that the court thinks that whoever gets interim bail goes out.
Whoever.
Wait, let me come.
My lord.
This court never says so in respect of locals. Only in case of outsiders, the court has a apprehension and which is proved
in that case. In that case, my lord, I can. In that case, I pray apologies.
You are probably not ready with this case.
No, my lord.
From your anxiety, I feel that you are not ready.
But gotti jinsa
You are professional.
Local I cannot face for that.
No. I have granted you interim bail twice.
My lord, yes.
So this interim bail cannot be granted as a matter of course.
I'm not
only under exceptional circumstances interim bail is granted.
My lord, there are references which I have showed to my lord that
in such and such situations, my lord,
No, there what has happened, the Supreme Court has taken note of the fact that he was in custody for nearly 3 years and interim bail kotha kodi paise no paise
absolutely not, my lord, quantity 841 kilo. It is quantity 40 quintal. It is 8 times more, my lord.
It is not a question of the quantity, it is a question that which comes up here for consideration is you have already been granted lenience.
My lord, in that case, my lord, I'm not, my lord, I'm stating it out of the court settlement, my lord. But in that case, my lord, below commercial quantity, they are being punished for 10 years, and also, my lord, 10 quintals also they are being punished for 10 years. So it varies with the quantity as well as the sanction of punishment, my lord. I'm not stating that. I'm not coming into that. But only I can pray that, my lord, he is being a localite, my lord, he is the only son of his father and he is a poor person, my lord. For that reason, I can pray for that.
No. I have already granted you indulgence. I mean, indulged you, granted you liberty.
But he is in custody since 31 months.
Otherwise, what will happen is the judicial system will become a mockery. It will become a mockery of the judicial system. So, no, there cannot be any bail. Dithara interim bail diachi 3 months, 2 months, 5 months. 5 months has been given on interim bail.
Maybe kept for after the vacation, maybe.
All right, after vacation. Is this matter after vacation? Yes.
Obligement.
Item 22.
22.
May I please also? On anticipatory bail, my lord. In case-
Yeah, anticipatory bail.
Yes, sir. The earlier order was disposed of in respect of the brother of the present petitioner.
You are that other person was the
Brother of the present petitioner, my lord. For which he.
No.
Krishna Bandnaik.
Krishna Godnaik.
Yes, ma'am.
Yeah, but it was rejected.
Though the house.
I directed you to
Yes, yes.
surrender and move for bail in the court.
In his own merit.
Or it will be considered as its own merit.
Krishna Bandnaik.
Yes.
He is the brother of the Krishna Bandnaik.
No, what is the allegation against him? What is the FIR?
That is under annexation number 1, my lord.
Annexure 1.
Yes, my lord.
Annexure 1.
That the
What is the allegation against him?
allegation against the present petitioner, when the informant along with other staffs proceeded and they found some jury bags were stacked in the veranda of the.
Yes,
house.
Mr. Mishra. What is the allegation against
My lord, ganja was seized from the house of the Krishna Bandnaik, my lord. And by seeing the police person, 3 accused person, they fled away.
He is the brother of Krishna Godnaik.
Brother, but present petitioner is identified by the local officers, all 3, including the present petitioner, my lord.
How? On what basis they could identify?
Lord, as
How
per
they
the
did? How they identified?
FIR, my lord.
No, FIR is allegation.
As
local officer of the area, myself
and ASI Escobar are able to identify the culprits as Krishna Bandnaik, Babula Bandnaik, and Sundar Rai Bandnaik of village such and such being seen by police party arrived there.
Bandnaik, one can understand because it was recovered from his house.
His house.
The house stands in his name. So,
Yes.
but what about this person? What is your name? Babula.
Sundarai Bandnaik.
Sundarai Godnaik. Bandnaik. Local person, ମୁଁ ଜାଣିଛି ସେମିତି କଣ ହବ? So identification, will it stand in the court?
Let me obtain the case diary.
Yes. Up to that case diary be obtained. Then State Council shall next setik tho. Let this matter in the week commencing 13th May.
Item
Interim.
13th May.
Interim.
कौन interim?
Use quantity, my lord, 306 quantity.
दिया है इधर कुछ.
All right. No course of action shall be taken till then.
Item 23.
23 may I please? Tied up matter in the previous bail application, your lordship. Please to release the prisoner on bail, subject to condition, your lordship. And NBW has been issued against this prisoner.
Same order?
Yes, same order. Case of 2015, same
order.
Obliged.
Item 24.
My lord, if the prisoner is apprehending arrest in connection with the GR case number 394/23 arising out of Hon'Ble PS case number 401/23 pending in the court of JMFC Hon'Ble for commission of offence alleged under section 379(4)11.
Driver allowed and he is the owner of the JCB, man.
The 2 other co-accused persons have already been granted to.
Same order. All right, same order.
Item 25.
My lord, your lordship also granted co-accused persons.
Pankadhara Dharua.
Yes,
my lord. petitioner also standing in similar footing.
Yes, ma'am.
Same order.
Item 26.
My lord, the case of offence under section 20B2C of NDPS Act, my lord. And your lordship has granted bail to one of the co-accused and similar footing.
Bhagwan Khotua.
Well, yes, miss. Bhagwan Khotua, my lord. And on the statement of
Bhagwan Kalia Violin
the
Position.
co-accused, this present petition has been implicated, my lord.
Yes, same.
Yes, ma'am.
Same order.
Same, but confession of co-accused Narottam Palia.
While he was in police custody, but
yes, ma'am.
Yes, ma'am.
it
Police.
becomes inadmissible.
Same एतरे लिखा है जी 350 kg, it is 850 kg.
850 kg.
अच्छा 850.
The order itself.
Order रे लिखा है.
Previous order 350 अछि.
Yes, ma'am.
It 850 kg, my lord.
इधे wrong टा रह गया कौन करिए? ये modification कर 6 of 2023. पहले modification पे नहीं है सो तो modify कर दो. Order से नहीं हम तो modify कर. Same order.
Obliged, my lord.
Item 27.
May I please? My lord, the second round of bail application of the present petitioner. And in the meantime, one quite
Amir Khan.
in the same footing. So, my lord also granted bail.
Amir Khan has already been granted EK. Mohammed Aspak.
No, this is
Amir
Khan, madam.
Aspect and has granted bail.
He was not named in the affair, so his implication was not there at that point of time. But charge sheet has been filed, his name is there. He is the driver of the complainant and he has only introduced the
Kaifi Khan.
Yes.
Kaifi Khan to?
Yes. And no, direct allegation.
Take what keeps KJ.
Aspect.
Aspect to reject is you. This is what I find 1100 11099 up to 123.
Third court he has given the order.
All right. The
Page
petitioner
19.
apprehends arrest in connection with such and such case.
Page 19.
It is alleged that the petitioner had introduced the informant to one Kaifi Khan.
Yes.
Who cheated him with the assurance to eliminate negative spiritual energy and took rupees 21,95,000 from him. Insofar as the petitioner is concerned, he appears to be the driver of Kaifi Khan.
Uncle.
Complainant.
The present petitioner is the uncle.
Complainant. Complainant or driver?
Is the
No.
Yes, yes. Amir Khan.
No. He's the uncle.
What instruction I have got today morning?
He's the uncle.
Is the uncle of Kaifi Khan.
Kaifi.
There is no other evidence showing his complicity in the alleged occurrence. It is submitted that the co-accused persons have been released on bail as per order passed by the court below. Under such circumstances, surrender release on bail.
29.
28 तक कौन लगी? Oh, withdraw. 29?
No instruction.
No instruction. The court below is directed to inform whether the petitioner, after being granted interim bail by this court, has surrendered to custody or not. Yeah, if not, let this matter in the week commencing 13th May.
Item 30.
30 my lord, permitted to withdraw.
Permitted to withdraw.
Item 31.
Mr. Paul was here. Pass over.
Item 32.
May I please your lordship. Lordship, the petitioner is in custody since 21/3/2020, more than 4 years and above. Out of 45 charge sheeted witness, only 23 witnesses are examined. And I have already filed the deposition copy. And lordship.
Who are the eyewitnesses?
Eyewitness, my lord. Complainant is the eyewitness.
No,
my lord.
no direct knowledge about
My lord, your lordship, see from PW2.
PW8 is also
Three.
an eyewitness.
Yes.
PW8 is also an eyewitness.
You are for the informant?
PW6.
No, PW2 টা ଟିକେ পড়া যাও।
Yes, ma'am. PW8. Yes.
Along with President Srikanta Sahu, the accused. What is your name? The name of the accused?
Petitioner name is Srikant Sahu.
Srikanta Sahu, acha. I, along with the President Srikanta Sahu, Secretary Bikram Das and Babu Naik of Village Bhattok Attorney. Then PW8.
PW3 also.
PW3.
3 also. Anirudh.
PW3 is same as PW2.
Yes. And thereafter PW6.
Yeah, PW8.
Informant.
6 is not an eyewitness.
PW2 ଭାଗଚାଷୀ କରୁଥିଲେ ସେ as because the petitioner is the village president ଥିଲା ସେତେବେଳେ ସେ ତାର due to political rivalry ସେ ତାକୁ
No, there is direct evidence.
PW7 is also post
May not be murder, may ultimately turn to 304, part 2 or 1, part 2. But there is direct evidence.
Yes, ma'am.
Having
Gunshot injury,
6 numbers of criminal antecedents also. And earlier 2 number of applications were once withdrawn, and this honorable court has been pleased to release him on 2 occasions. On interim bail for 4 weeks and 4 weeks by order dated 15/5/23 and 8/6/23.
serious ଥିଲା ସେ
Another IO was rejected by a
ପାଇଁ ଥିଲେ ସେ
coordinated
life is
bench.
in serious condition too. And at that time he was gone on interim bail and then released in the meantime in the fixed period.
No, direct evidence. Clear case of conviction.
And also lots of ସ୍ତ୍ରୀ ଦେହ ବି ଏବେ ବି ଅଛି ଘରେ କେହି ନାହାନ୍ତି
କଣ କରାଯିବ?
interim bail.
ବୋଧକରେ ମାଛି direct evidence ପୁରା କହିଛନ୍ତି।
PW5 Babu Naik denied the fact. And also
Maybe it will not wash away PW1, PW2, PW3, PW6 and PW8. So 4 eyewitnesses.
PW7 Arun Kumar sir says
PW7 is the
direct
first
knowledge
occurrence.
about the fact only has
No,
the informant.
even assuming it will not be 302, it will be 304 part 2. That can be said. Part 2 ବି କହିବ, part 1 ବି ହବ, କାହିଁ ବନ୍ଧୁକଟା ବାହାର କରି ମାରିଛି ନା।
ତାଙ୍କ ପରିବାର ଯୋଉଟା କହୁଛନ୍ତି ସେମାନେ ତାର
sudden quarrel ରହିଛି, sudden quarrel ରହିଛି, so it will not be culpable homicide, but culpable homicide not amounting to murder. If it is not amounting to murder under 301 part 1, 304 part 1 or part 2, that the court below has to see, but there is direct evidence.
next week.
And next week କଣ?
Interim
Interim?
That's it, ସେ ଯୋଉ ଦୁଇଥର ଯୋଉଟା ଆସିଲା
ଦିଥର ଯାଇଛି interim ଆଉ ଥର।
7699 ଯୋଉଟା
ଆପଣ ଏଇଟା ଶୁଣୁଥିଲେ ଜଣକୁ ଦିଥର ଦେଇଥିଲି ବୋଲି ଦେଲେନି।
ନାଇଁ ଲଟ୍ସି ମୁଁ ସେ କଥା କହୁନି। Before submission of charge sheet ସେଟା ଫାଇଲ ହେଇଥିଲା ଦିଟା ଯାକ ବେଲ ଯୋଉ ସାର୍ କହୁଛନ୍ତି 6324 2020 and also 7699 2021 before submission of charge ମାନେ ଚାର୍ଜ ପୂର୍ବରୁ ସେଇଟା ଫାଇଲିଂ ହେଇଥିଲା। and ଲଟ୍ସି ଇନ୍ କଷ୍ଟଡି 20 ରୁ ରହିଲାଣି 16/3/20 ରୁ।
ପୁରା ଜୀବନ ସାରା ରହିବେ। ଭାରି ଦୁଃଖ।
କିଛି ଦିନ ପାଇଁ ନହେଲେ ଇଣ୍ଟରଭିଉ ରେ ଆସୁ
କିନ୍ତୁ
ଇନ୍ ଟାଇମ୍ ରେ ସରେଣ୍ଡର କରିବ 2 ମାସ ପାଇଁ ନହେଲେ ସ୍ତ୍ରୀ ବି ବହୁତ ସିରିୟସ୍ କଣ୍ଡିସନ ରେ ଲଟ୍ସି ଅଛି।
Where is that finding? Where is that petition? Where is that document?
Let's kindly glance the PW11 page 30A. The nephew जो कहला I had had nephew of the informant से कहला मैं खाली सुनी ची। Direct evidence कहीं ना दी।
No. Where is the evidence relating to the illness of the petitioner's mother or wife? Who?
Wife.
So where is that evidence? Where is the document? Come with the document. come with the documents, file an application, it can be considered.
Lordship, my auditor.
Next week as paid for.
The same was rejected on 19/2/2023 by.
Interim bail
Yes, interim application was
rejected by this court.
No, coordinated bench of.
In BL appeal number?
This BL appeal number, IA was rejected, your lordship, on 19/2/2023.
Lordship ସେଠି ତାର ଯୋଉ ଅଲ୍ଟ୍ରାସାଉଣ୍ଡ ରିପୋର୍ଟ କିଛି ଦିଆ ହେଇ ନଥିଲା ଅଲ୍ଟ୍ରାସାଉଣ୍ଡ ରିପୋର୍ଟ ସେମାନେ କେହି ଘରେ ନଥିଲେ ସେ ଆଣିନାହାନ୍ତି ଅଛି ତାଙ୍କ ପାଖରେ ସେ ହ୍ୱାଟ୍ସଆପ ରେ ପଠେଇଥିଲା ଏଟା କ୍ଲିୟର ଆସିଲାନି
ହଉ ଦେଖିବା
ମୁଁ ନେକ୍ସଟ ୱିକ୍ ଦାଖଲ କରିଦେବି
33
Obliged.
Last occasion, your lordship has sought for a report from court below that is under annex X perhaps.
Status of trial.
Status of trial below. Targets.
The court below has submitted a report stating that none out of 21 charge sheeted witnesses has been examined so far. Keep it rolling.
My lord, custody since 31/8/22.
The petitioner is in custody since 31/8/2022 in connection with such and such case. It is alleged that the petitioner, you are in possession?
Yes, 307 kg.
Only petitioner or somebody else?
Other 4 accused are also there, my lord.
Petitioner, either person ଅଛନ୍ତି?
ଏଇଥିରେ ଜଣେ ଅଛି.
The petitioner and four other, no, 3 other persons. And 3 other persons were transporting contraband ganja weighing kete
307 kg, 200 grams.
307 kgs, 200 grams on 2 motorcycles when they were apprehended by police. Learned counsel for the petitioner submits that the petitioner's right to speedy trial stands violated. Kahara. Speedy trial stands violated. Is seriously affected in view of non-commencement of trial, despite his being in custody for more than 1.5 years. He therefore submits that, notwithstanding the bar under section 37 of the NDPS Act, he should be released. The State Council has opposed the prayer for bail by submitting that the quantity of ganja seized from the possession of the petitioner is very high. Taking into consideration the submissions as above and the materials on record, and having regard to the long period of detention of the petitioner in custody without commencement of trial, I am inclined to take a lenient. The bail application is disposed of, directing the court to release the petitioner on interim bail for a period of 3 months.
34. My lord, from a vehicle, my lord, 126 kg of ganja was seized, my lord. There are 2 persons are there, my lord. And the petitioner is in custody since 5/8/2022, my lord. And meantime, my lord, the co-accused has granted thrice interim bail, my lord. I pay, my lord, interim bail.
What is the quantity?
126 kg. 125 kg, 500 grams.
That cannot be cited.
No.
Interim bail order cannot be cited as a precedent. What is the status of trial?
Trial, my lord, 1, 2 to 3.
No, 2 witnesses have been examined out of 3. At this stage, how can I grant you bail?
Lord,
now, in the meantime, that was in January. Now, he gave that report in December, saying that the case is posted to January 2024. Now, in the meantime, what is the status?
my lord, there is no development.
ଜଣେ ମାତ୍ର witness ରହିଛନ୍ତି. So the court below is directed to submit a up-to-date status of the trial. This is matter next week. In the week commencing 6th day. This order be communicated to the court below forthwith. है ना?
Item 31 not pressed, my lord.
Item 31 not pressed.
Item 35,
35, pass over.
Pass over.
item 36,
May I please, Madam?
Hmm.
The petition in custody since 19/10/2020.
सर मैं लाइट लेवल में से बाउंड करूं Alright, the court below is directed to submit a report regarding status of the trial. Yeah, outsider काहे की रखे? ये ना outsider. Incidental होगा नहीं.
status reputation
कौन है?
ଆଉ ଜଣେ ଅଛି co-accused
Alright.
9699.
This is matter in the week after vacation.
Item 30, status report.
Maybe yes. Illustrious, unless offensive 272, 278, 308, 302, 34, and 47A, 52 BR and XI lordship. Your lordship, the allegation that lordship, some person became sick, they are admitted in the medical. After 3 persons has been died. In the mental lordship, what happened? The 6 persons was charged. Out of 6 persons lordship, 5 persons are facing trial and they are acted from the charge. On the basis of that lordship, the prosecutor has to fail the established case lordship. In the meantime lordship, the petitioner approached this honorable court and direction of this honorable court, petitioner is a surrender and he is in custody more than 1.5 year lordship. In the meantime, in split of trial lordship, 24 witness has been examined except PW3 in an informant. All are on hostel lordship. I have the copy of the deposition lordship.
What the informant has said?
Lordship, informant is a police officer lordship. Except him lordship, all are on hostel lordship. I am the custody 1.5 year lordship.
Yes, what do you say?
Lordship.
It's a liquor tragedy. And the present petitioner, one Sankar Maji and this present petitioner are the kingpin. And that Sankar Maji has been
This is
acquitted.
in your trial, split up trial.
Lordship, my turn. Sankar Maji.
What happened in the original trial?
All the time, all are actor lordship.
Acquitted.
Or not all, 5 persons acquitted.
5, 6 out of 6, 5 is the trial, and Sankar Lal is along with
Sankar
this.
Maji and this present
He also
they are the
acted.
kingpin, my lord. But that Sankar Maji has been acquitted.
There is no evidence. The petitioner is in custody since?
Lordship, 18-10-22.
In that original trial also 72 witnesses examined. No one else.
18/10/2022 in connection with such case. It is alleged that the petitioner, being associated with several other persons, was trading in spurious liquor, consuming which several persons died, resulting in a liquor tragedy.
3% died.
Some person died. It is submitted that in the original trial, all the co-accused persons have been acquitted for want of evidence. In the split up trial being held against the petitioner, also none of the witnesses have supported the prosecution case.
Except PW3.
PW3 is the informant.
He is a police officer.
Except PW3, who incidentally is a police officer. So, as such, there is no admissible evidence to show the complicity of the petitioner in the alleged offence. Taking into consideration the above facts, and the period of detention in custody, I'm inclined to allow the proof of bail.
39.
That's all.
39 permit to conduct 40 law. That item 39 is similar to 33 million.
33 कौन आला?
Your lordship is granted
Interim bail.
interim bail for a period of 3 months.
Same matter.
Same matter. Two younger brother was moving.
All right.
33.
All right.
2 months, na?
3 months.
3 months. Same. Item 40.
May I please, your lordship? Yes, my lord. I was released on an interim bail. And after completion of the such interim bail period, I surrender and file my surrender certificate. That is, your lordship, 29 to 2024. Parapet is in record.
If the surrender certificate is not there?
I filed it, your lordship. On 3/2/24 file করছি।
It's not there on record.
It's a memo.
Achi, record achi. Yes. No, no. So you go to. Yes, what is the matter?
The seizure of the lordship, brown sugar 1 kg 190 gram. Now I have also another interim bail application. Now the spinal cord disease by se bail jaitra interim. Rohilani ବର୍ଷେ ମୁଁ ତ ଥରେ ଯାଇଛି ଭାଉଲେସନ କରିନି ଆସି ସଲ୍ଡର କରିଛି ଟ୍ରିଟମେଣ୍ଟ
This is brown sugar.
And huge quantity 1 kg 190
This is
gram.
brown sugar.
And
The consideration will be totally different. in
six
case of brown sugar.
antecedent 1
the
is
health condition report as well magudu so that
What?
take into consideration.
It is submitted that the petitioner's health condition is has worsened. Then state council shall take instruction. Release this matter in the week commencing 13th May. Yes.
Your pleasures.
I don't know 42.
42 may I please, madam?
The petitioner in custody since 24/5, he was granted interim bail to attend the obscure ceremony of his father, and he has in the right time he has surrendered.
The petitioner files copy of the surrender certificate showing surrender of the petitioner on 22/9/2023 after expiry of the period of interim bail. Yes.
Custody since 24/5/23. Quantity of ganja involved 48 kg 600 grams. Charge sheet has been filed. Local man.
The petitioner is in custody since
24/5/23.
24/5/2023 in connection with such and such case. It is alleged that he was in possession of contraband ganja weighing 48 kgs.
48 kg 410 grams.
48 kgs 410 grams when he was apprehended by police. It is submitted that the statutory formalities of NDPS Act relating to search and seizure were not complied with. Further, he has been in custody for more than
Near about 1 year.
for nearly 1 year without commencement of trial. Taking into consideration all the above facts, I am inclined to allow the proof of bail. Let the petitioner be released.
All please.
Item 43.
The petitioner is in custody since 13/11/2022. My lord, last occasion will also call for the status.
The court below has submitted a report stating that 2 out of 18 witnesses have already been examined. Yes.
That's a local man.
700 kg ganja, and he has also antecedent of the similar nature.
Yes, Mr. Das, how many? कौन करिए?
Interim bail master. Local man.
700 kgs. Too much. Too much. Permitted to withdraw.
Private.
Okay, then permitted to withdraw. None.
Lordship directed to complete the trial with
The court below is directed to conclude the trial as early as possible, preferably within a period of 6 months.
hello.
Item 44. I prefer adjournment.
Next week is paid for.
As soon as it should, after vacation.
After vacation.
Item 45, rate results.
The cause of death or disease allergy poisoning. And I am in remaining custody 14/5/2023.
You are the husband?
Husband is
You are the case diary?
Yes, ma'am.
Yes.
and the allegation is there so far the statement reveals 1:1 that the husband after marriage having extramarital relationship and out of such relationship there is a disturbance arose between the husband and wife regarding the relationship and they separate to each other even if releasing the one cottage. On the date of alleged occurrence before the night, the wife had been to the husband and requested to call and sit together. The husband denied. Then she became hurt on the next day, committed suicide by consuming poison.
Marriage is in the year 2019 and having a child. The PM report, my daughter, it was asphyxia as a result of poisoning and it was sent to the SFSL, but that report has not.
Let us treat it as poisoning.
My lord,
Let us treat it as poisoning.
my lord, first check it
Let
out.
us treat it as poisoning. Then what is the
It tells my lord that the reason is that extramarital life of the present petition. For that reason,
that could be a good reason. That could be a good reason for somebody to commit suicide. देखिए कौन statement अच्छी?
informers, my lord, that
This may be a cause of action for divorce. This is not case of abetment lordship.
ଯେ 8/21 ଆମର ଝିଅ ଗୋଟେ ପୁତ୍ର ସନ୍ତାନ ଜନ୍ମ ଦେଇଥିଲା ସେତେବେଳକୁ ଆମର ସେ ଆମରି ଗ୍ରାମର ଈଶ୍ୱର ନାୟକର ସ୍ୱାମୀ ଛାଡି ଆସିଥିବା ଝିଅ ସେ ଆମରି ଗ୍ରାମର ଈଶ୍ୱର ନାୟକର ସ୍ୱାମୀ ଛାଡି ଆସିଥିବା ଝିଅ ସୁଜି ସହିତ ଖରାପ ସମ୍ପର୍କ ରଖିଲା ଏ ବିଷୟରେ ମୋ ଝିଅ ଜାଣିଲା ତାପରେ ସ୍ୱାମୀକୁ ଏମିତି କାହିଁ କରୁଛ ବୋଲି ପଚାରିଲା ଫଳରେ ସେମାନଙ୍କ ମଧ୍ୟରେ କଳିକଜିଆ ହେଲା ସେମାନଙ୍କ ଦାମ୍ପତ୍ୟ ଜୀବନ ଭଲ ରହିଲା ନାହିଁ ଓ ସବୁବେଳେ ଝାମେଲା ଲାଗି ରହିଲା ଏହି ବିଷୟରେ ମୋର ଝିଅ ମତେ ଜଣାଇଥିଲା ଶେଷରେ ମୋର ଝିଅ ସହି ନ ପାରି 4/5/23 ପାଗଳ ନାୟକ ପାଖକୁ ଯାଇ ଏସବୁ ବିଷୟରେ କହିଲା ପାଗଳ ନାୟକ ଘଟଣାର ସମ୍ବନ୍ଧରେ ଜାଣିଲେ ଏବଂ ତା ଝିଅ ସୁଜିକୁ ଗାଳି ଦେଲେ ଏହା ଶୁଣି ସୁଜି 5 ଦିନ ଏହି ସବୁ ବିଷୟ ଆମ ଜ୍ୱାଇଁ ସିଲୁକୁ ଜଣାଇଲା ସୁଜି ଠାରୁ ସବୁ କଥା ଶୁଣି ସିଲୁ ଘରକୁ ଫେରି ମୋ ଝିଅକୁ ବାଡେଇଲା ସେଇ ଦିନଠାରୁ ମୋ ଝିଅ ମାନସିକ ଦୁଶ୍ଚିନ୍ତା ଥିଲା ସିଲୁ ମୋର ସ୍ୱାମୀ ଗୋପବନ୍ଧୁକୁ ଏହି ବିଷୟରେ କହି ତା ଘରକୁ ଆସିବା କହିବାରୁ ମୋର ସ୍ୱାମୀ ତାଙ୍କ ଘରକୁ ଯାଇ ସେମାନଙ୍କୁ ଭଲରେ ଚଳିବା ପାଇଁ ପରାମର୍ଶ ଦେଇ ଫେରି ଆସିଥିଲେ କିନ୍ତୁ ସେଇ ଦିନ ଠାରୁ ଝିଅ ସୁଚି ଓ ଜ୍ୱାଇଁ ଅଲଗା ଅଲଗା ଶୋଉଥିଲେ 13/5/23 ଦିନ ମୋର ଝିଅ ତାର ସ୍ୱାମୀକୁ ଘର ଭିତରେ ଶୋଇବାକୁ ଅନୁରୋଧ କଲା କିନ୍ତୁ ଜ୍ୱାଇଁ ତାର କଥା ନ ଶୁଣି ବାହାରେ ଶୋଇଲା 14/5 ଉପର ବେଳା ମୁଁ ଶୁଣିଲି ଯେ ମୋ ଝିଅ ଏମ୍ସ ରେ ଚିକିତ୍ସିତ ହେଉଥିବା ବେଳେ ମରିଯାଇଛି The sole reason is that extramarital life. That is the reason.
Charge sheet submitted. I am remaining behind bars on 14/5/2023. Administration condition.
But she has a child, my lord, that minor child.
Instigation cannot be ruled out. Because having a extramarital affair and subsequently followed by the assault and a quarrel.
Assault रागे किसी injury pinjury किसी नहीं नोट.
Injury assault or सब assault कौन injury और चटंडे पकड़े कौन injury है वो injury report देखिए जाना पड़ेगा. सेमती किसी नहीं.
Maybe lead to some quarrel between husband and wife regarding their relationship.
Let some more time go. You keep it pending.
छोटो छुआटा अच्छी हो रहा है.
How can the investigation?
She was not examined.
Okay.
Other villager statement is there, but that
the lady should have been examined.
yes, lady and her father, because he has disclosed this matter before the father.
All right, the petitioner is in custody since
Sincere lordship 14/5/2023.
14/5/2023 in connection with such case, it is alleged that the petitioner, being the husband of the deceased, instigated her to commit suicide, abetted her suicide because of his extramarital affair with another lady. It is stated that the petitioner had married the deceased after a love relationship, but developed relationship with another lady. The deceased protested, for which the petitioner was angry on her. So this also caused mental depression of the deceased. The General Learning Council with the petitioner submits that even accepting the prosecution case on its face value, it would not be a case of instigation. Rather, the materials on record would suggest that the deceased, being depressed, took the extreme step. Para. Then State Council, while opposing the prayer for bail, submits that there is clear evidence that the petitioner had an extramarital relationship which caused mental depression. Which caused mental depression on the of the deceased. Further, just prior to the occurrence, the deceased requested the husband to sleep in the same room, which was refused by him, and thereafter she committed suicide by consuming poison. After considering the rival submissions and the materials on record, this court finds that there are several, in the prima facie, there are several gaps in the investigation, in as much as the lady with whom the petitioner is said to have had a relationship outside his marriage has not been examined. Stop. Her father has also not been examined, who is said to have had a role to play in the matter. Therefore, prima facie, it is difficult to conclude that the deceased was instigated by her husband to commit suicide. Considering the above facts, as also the period of detention and custody, I am inclined to allow the prayer for bail. Let the petitioner be released. The condition karo. We shall personally appear before the court in session over the matter on each date of posting of the case without fail. No representation through counsel shall be allowed under any circumstances. That's all. That's all. Obliges. Sitting so. Sitting so.